हाँ जी।
हेलो चेक माइक टेस्ट। हेलो चेक ठीक।
11.
Made, Your Lordship. Well, if your lordships could take the bare act of the Industrial Disputes Act, I'll be very brief.
Yes.
Now, I was on 2N, 2 subsection N, which
No,
defines
just-
public utility service. Sorry.
Two things I wanted to bring to your Lord's attention. I've been able to place my hands on the reference order, just as I mentioned to it. We could trace out the old paper book, and then I'll just place it before your Lordship got copies of it and give it to you.
Thank you. Thank you, Mr. Chairman.
But other side. Everybody.
Yes, Mr. Singh.
And then I thought nice to listen to the passionate and well-meaning arguments on the other side. I would like to listen to some of them. They throw some good light on probably our rejoinder. Just want to pay my compliments to my learned friends.
Thank you. Very, very, very kind of the learned attorney. We are grateful.
2N, public utility.
2N, just see the scheme. Oh, I'm sorry.
No, I just gave the copy of the referral order.
Yes.
Very good.
So the scheme of 2N is public utility service means any railway service, transport service, passage by goods by air, any service in or in connection with the working of any major port or dock, any section of an industrial establishment dealing with safety and establishment, any postal, telegraph or telephone service, any industry which supplies power, light or water to the public, any system of public conservancy or sanitation. So these first 5 entries were there right from when the Constituent Assembly approved the Act in 1947, when the Act was enacted. The 6 was also there. Any industry specified at that time, it was just the schedule. First schedule wasn't there. The schedule which the appropriate government may have satisfied that the public emergency, etc., requires. But while enacting it in 1947, 5 entries were already the Constituent Assembly already put in the first 5 entries in the schedule, which your lordships will find in the schedule. Those 5 entries were there by legislative action, not by appropriate government action. Just kindly come to the schedule for a moment. I'll just make the point. If your lordships come to what is now the first schedule,
Yes.
in 1956, the other schedules were added. So this became the first schedule. In my book, it's at page 107. Lordship may have it somewhere around there, at the foot of 107.
Yes, 108 it is.
My lord. Now, the first schedule says,
Transport, banking, cement, coal.
but see the title of the first schedule, industries which may be declared to be public utility service under subclause 6 of so and so. So the definition is industries. Now, the first 5, transport other than railways, because railways was already there in 2 and 1. Banking, cement, coal and cotton textiles were already there. Now, 6, 7, 8, 9 and 10 were again brought in by legislative fiat in the 1956 Amendment Act. So in the 1956 Amendment Act, when that is Act 36 of 1956, when the other schedules were added and this became the first schedule, simultaneously these 5 were added, which include, your lordship will see, defense establishments, service in hospitals and dispensaries, fire brigades. The others from 11 onwards have been added by notifications under 2 and 6, right? So the fact that Parliament in 1956 was cognizant of what is industry and has added these as industries, not just industries, but industries which are public utility services, was there. Now, I pointed out to your lordship yesterday that under section 12, the conciliation officer is mandated to entertain conciliation, to admit in conciliation a notice of strike or lockout in a public utility service. But what I missed was section 20. Your lordship may just take this, just note it down. Section 20 is a deeming provision which says the moment a notice of strike or lockout in a public utility service is received by the conciliation officer, it is deemed to be admitted in conciliation. Section 22 then says that no strike or lockout will be commenced in a public utility service without a notice of not less than 14 days and not more than 6 weeks. prior to the commencement. So in those 14 days, it gets deemed to be in conciliation, and consequently, under section 24, the strike or lockout becomes illegal if they still commence it
Yes.
without the conciliation getting over. Because section 20, 22, 24 is the scheme of how strikes and lockouts are completely abated, completely prevented till now. Section 20 is commencement and conclusion of proceeding. The proceeding concludes when the conciliation officer records failure. Either he records a settlement or he records failure. On failure, immediately the appropriate government makes a reference in public utility services. And again, there is a bar on strikes and lockouts till the conclusion of the reference. It is a scheme which is, I'm surprised not that state governments want this scheme to be jettisoned for certain classes of industries, when this is a scheme which is there to protect not just the workers. We of course want the protection of workers, but to protect the industries, to protect the employers, to protect the public at large and the nation as a whole. This is the sort of scheme which is there with public utility services, which include hospitals, which include conservancy, which include sanitation, which include municipalities, universities, etc., etc., etc. Now, my lords, now kindly come to 2A, because the assumption on the other side, the learned ASG, Mr. Natraj, my learned friend, Mr. Shadan Farasat, etc., arguing that industries which are run by the government, industries which are run for fulfillment of directive principles of state policy and so on and so forth, could never have been industries. Now, please see what is the definition of appropriate government. Appropriate government means in relation to any industrial dispute concerning any industry carried on by or under the authority of the central government or railway company, or concerning any such controlled industry. Controlled industries are under 2EE. My lord may just note it. 2EE is controlled, they come under control only to preserve the industry for public interest. So private industries become controlled under 2EE for the purpose of preservation of the industry in public interest. Then overly, your lordship will see Employee State Insurance Corporation, Board of Trustees under the Coal Mines Provident Fund Act, Central Board of Trustees and State Boards under the Employees Provident Fund Act, Oil and Natural Gas Commission. Now, these Board of Trustees, normally we would have thought a Board of Trustees of Provident Fund would be a sovereign function. In common parlance, we would have imagined that this is the sort of thing which is a function of the state. This is not a function of an industry. But the parliament conceives of it and sees it as very much a part of industry, where industrial disputes can take place in the Board of Trustees. Now, Oil and Natural Gas Commission, deposit, I'm just skipping over them and just highlighting some. Deposit Insurance Credit, Airport Authority of India, Export Credit Guarantee, National Housing Bank, Air Transport Service. Now, see towards the end of that, or a banking or an insurance company, a mine and oil field, a cantonment board, or a major port, any company with not less than 51% of share capital held by the government, the central government, or central public sector undertaking, subsidiary companies, autonomous bodies owned or controlled by central government. Appropriate government is central government. Now, the reason why I've cited banking companies, 2BB defines banking company includes all, including Reserve Bank of India. So the body which formulates monetary policy of the country is an industry under this. Yes. So I'll close the act immediately. I've placed the relevant points in a written note. May elaborate on it. Now, when it is argued that, look, there are already certain protections, why should the definition of industry be read broadly? The ID Act itself, I'm sorry, I said close the act. The ID Act itself contains a series of safety valves. Those safety valves include the power of the appropriate government to completely exempt industries from the provisions of the Act in the public interest and in the interest of preservation of industry. So just make a note of the provisions. Your lordship may note Proviso B to Section 9, capital A. Proviso B to 9A, no notice of change is required where the fundamental rules, etc., and all kinds of government rules are applicable, or any rules notified in that behalf by the appropriate government. So for instance, if there are service rules in a particular industry, let's say for ONGC has service rules, they can notify it and say, no 9A notice would be required there because there's already a service rules. 9 capital B allows wholesale power to exempt an entire industry or a class of industries from 9A. For what purpose? Where serious repercussions to industry and public interest are likely to ensue from the requirement of not making changes. Please see 9B. And 9B applies to private sector and public sector both. 9B says power of government to exempt where the appropriate government is of opinion that application of 9A to any class of industrial establishment or any class of workmen employed in industrial establishment affect the employers in relation thereto so prejudicially that such application may cause serious repercussion on the industry concerned and that public interest so requires, the appropriate government may by notification in the Gazette direct the provisions of the said section shall not apply or shall apply to subject to conditions, etc., etc. So there's again, appropriate government is empowered to exempt. Then section 19, subsection 4 allows the appropriate government to curtail the period of operation of awards. 19, subsection 4.
Yes.
My lord may just note it. Then section 36, capital A says that awards or settlements can be referred by the appropriate government to a labor court or tribunal for interpretation where there's any doubt as to the interpretation. So if there's an award holding the field for 20 years, let's say, it can still be referred because the appropriate government feels that this needs reinterpretation. And then please see 36 capital B. This I would ask your lordships to kindly read. Please read capital B.
Yes, yes, please.
My lord. Power to exempt, where the appropriate government is satisfied in relation to any industrial establishment or undertaking or any class of industrial establishments or undertakings carried on by a department of that government, that adequate provisions exist for the investigation and settlement of industrial disputes in respect of workmen employed in such establishment or undertaking or class of establishments or undertakings, it may by notification in the official gazette exempt conditionally or unconditionally sub-establishment or undertaking or class of establishments from all or any of the provisions of the Act. Now, my learned friend, Mr. Farasat, wants your lordships to, wants in effect, without meaning any disrespect, wants in effect that the state government should shoot the gun off the shoulders of the Supreme Court. If the state government feels that some class of industries is protected and therefore they don't need the protection of the Industrial Disputes Act, they have an entire power. They can issue Section 36B notification. But no, we'll come and we'll shoot the gun off the Supreme Court shoulders and then we'll tell all the workers in our state that no, you were let down by the Supreme Court, not by us. Politically, we have kept ourselves safe. Is this the argument, Lord, before a 9-judge bench? After 48 years, please reinterpret a provision so that we can save certain private sector industries or public sector industries from the consequences of their ill doings. But do it by shooting the gun off the Honorable Supreme Court shoulder. You have all power. You have all power to exempt. Exercise your power. Don't come here and don't cry wolf after 48 years about it. So this is now your lordship may put down the act altogether. I won't. Lastly, my lords, Safdarjung Hospital. This is very important. Safdarjung Hospital had 3 fatal flaws in it, which are self-evident on the face of it. So for anybody to say, please reconsider Bangalore water supply because Safdarjung Hospital was holding the field and it's a 6-judge bench. Now I'll just enumerate those 3 fatal flaws immediately. The first is in paras 11 and 12, the Supreme Court went on the basis that ID Act definition of industry has been borrowed from Australia, and it's a fact. It was borrowed from Australia. They make a reference to the amendments of Australia of 1910, 1909, 1910. But what they reproduce there is the unamended section of 1904. And 1911, the amended section is what is the precursor to 2J of the Industrial Disputes Act. In my note, I have reproduced that. My note is at page 1 of volume 2, and your lordship will find, lords, at page 10. At page 10, I've reproduced. They've taken the wrong definition, the unamended definition of 1904. and use that to say means and includes wasn't intended to mean means and includes.
What's the next? There are three flaws you said.
So this is the first. And your lordship may just see the 1911 definition I've set out. I've got the full text of that. I can just, may I hand that up, because in our note, we've just put I've just put them, juxtaposed the three. So I can just hand that up. This may be read with page 10. That's the first note.
All right.
The second, my lord, have that? The second, please give copies to everybody, to the learned attorney and the amicus.
Yes, Mr. Singh,
The
please.
second, your lordship will find in from paras 21 to 24, without any basis, without any reasoning whatsoever, they said that hospitals are industry. Hospitals have all the characters of industry, but only if they're in the private sector. And no reasoning. And please just see page, volume 5, page 450 is the judgment. I just request your lordship to kindly see that.
We have noted that.
Yeah. Paras 21 to 20, and now
21 to
please
24.
see the last 4 lines, that para 23. Last 4 lines at para 23 at page 459 of volume 5.
Yes.
We may say at once that if a hospital, nursing home or dispensary is run as a business in a commercial way, there may be found elements of an industry there. Then the hospital is more than a place where people can get treated for their ailment. It becomes a business. But they say in Hospital Mazdoor Sabha, the court went wrong by applying that test to all hospitals. Now, I just asked myself the question, Lords, what is the difference as far as industrial disputes are concerned, as far as prevention of industrial disputes are concerned, as far as protection to the employer and protection to the workman, and most important, protection to the patients? What is the difference between a hospital, Safdarjung Hospital, Apollo Hospital, Medanta Hospital, and charitable Christian Medical College, Vellore, or some other charitable hospital? What is the difference? Does the industrial dispute change? And will that, if it's not a public utility service, would we not have flash strikes in AIIMS? Would we not have flash strikes in Safdarjung Hospital? What will happen to the patients then? If there's no conciliation and there's no protection given? So it's all very well to say this is a worker-centric statute, therefore reconsider it. No, this is a statute which seeks to balance all, because your lordships have seen interest of general public, interest of industry, in the section 36B or section 9B, where they say if it is critical for any industry, public or private sector, 9A can be completely avoided. So the Parliament was cognizant and very conscious of that balancing which was to be done. And that is the scheme of the act in which, we have to see this. So this is number 2. This is, in my respectful submission, virtually unreasoned. The finding.
Yes, we understood that.
I'm sorry.
What is the third one?
The third one is, that on 2N was shown to
You are
that.
referring to para 31?
Yeah, for paras 26 to 31, but yes, 31 is the final. The court,
In my view, 31 has a fundamental flaw.
my lord, I'm very grateful to your lord.
31 has a fundamental flaw. The honorable bench, constitution bench, proceeded by the notifications only,
That's right.
despite noticing that hospital services were introduced by legislation.
That's right. I'm very grateful. That was
Fundamental
the
flaw in
third fatal flaw, which I was just to place before your lordship.
Very
My lord, that's all, my lord. I tried to stay within the time limit with the honorable
Thank you,
chief
Mr.
justice
Singh. Thank you very much for cooperation.
indicated.
Yes, we will next start.
I'll put in a note. Just one thing I would like to say, not on the merits, but I was very happy when your lordships were pleased to appoint the two amicus curiae. I must say, whatever little I know or have learned about industrial law as well as service law has been learned from the learned amicus. My senior was Mr. J.P. Kama, And if I have learned anything, it is in his chambers.
That's most of them are items.
Who was my contemporary?
But notifications can issue in respect to enterprises which are not industries.
No, but not your- 3 or 4 generations, yeah, in this photo market report.
May I please, Your Lordship?
Yes, Mr. Azaria, 5 minutes, 5.
Well, I'll try to be as brief as
Yes.
possible.
Yes.
Yes, but I appear in item number 901.18.
No problem, you can just start.
My written submissions are in volume 2, page 240. But having regard to, my lord, the proceedings before this honorable court, I have revised it, my lord. May I just hand it over and
You
take your
can,
lordship through
no
that?
difficult.
May I just take your lordship through that?
You can submit the revised one, that's what we, yesterday also we requested everyone. Because after the arguments, you might think of.
It's in volume 6, my lord. So my, your lordship just have this. And lordship may keep the Industrial Disputes Act side by side my
Yeah,
written
yes,
submissions, my lord.
Yes,
My lord, the first thing is, my lord, the definition of industry, what your lordships are considering. Now, 2J says industry means any business, trade, undertaking, manufacture, or calling of employers. That is what. Now, what the triple test does is, my lord, triple test only exemplifies. Triple test is laid down in para 140 of the Bangalore water supply, namely systematic activity, cooperative cooperation between employer and employee in production of distribution of goods and services are inherent, are essential, are crucial, vital, necessary for all business, trade, undertaking, business, or callings of employer. So without, my lord, alternatively put, I have put in that, my lord, in my written submissions, alternatively put, no business, no trade, no undertaking, no manufacture, no calling of employers can be carried out unless there is a systematic activity, 1, in cooperation between employer and employee, 2, and for production or distribution of goods or services. Thus, my lord, the judgment of the Bangalore water supply only explains the term industry and does not go beyond the legislative intent, my lord. That is my first submission as to what the triple test is, my lord. There is a argument that the triple test expanded the horizon of industry, which is not visualized under the Act, my lord. In fact, my lord, none of those 5 activities, which is an industry, meaning can be undertaken without undertaking this triple test, my lord, and these are only explains the triple test only explains what is the meaning of industry. Secondly, my lord, the Industrial Disputes Act, right from 1947, has given benefits to the various workmen from time to time, a series of benefits, my lord, and these workmen who have, my lord, no bargaining power or unequal bargaining power, they are vulnerable and they are at the mercy of the employers, my lord, so far as the conditions of service are concerned. That's why the legislature have stepped in, my lord, and lordship may kindly see, come to my page 2 of my written submissions. The various benefits which are available to the workmen can be culled out only from the my lord, the beneficial provisions of the Industrial Disputes Act. I have tabulated them. I'll just point it out, 1 or 2 of them, my lord.
9A, 9C, 110A, we have seen everything. Yes, we have seen your note. Proceed further.
Lotships are so fast, Lord, I have not been able to go that.
We have seen it because we have to do our homework.
Yeah, I'm grateful to Lordship. So, my lord, for example, without 11A, can there be a reinstatement, my lord?
Elaborate.
Madam Indira Jaising has taken to.
Indira has argued well.
But there are other things, my lord. For example, Works Committee, there are Public Grievances Committee. For example, there are retrenchment compensation.
What none of you have referred so far is the unfair labor practice.
Unfair labor practice, I put that, my lord.
We know very well, you can proceed further.
If a lordships have seen, my lord, I see that lordships
Proceed
are much
further
more.
now.
If serial number 15, I've said unfair labor practice could not have been, my lord, prevented except if an industry, if an undertaking is not treated as an industry.
Yes, that's
And
it.
that's a very important, very wide meaning has been given in section 2RA, read with the 5th schedule, my lord, of that. Now, the third thing, Lord Indira Jaising has said, Lord, who has come to your lordship, my lord? They have,
That has been argued.
no, my lord, may I just, there is a little explanation in that. All the states, my lord, together across party lines, whether it is a BJP ruled state, whether it's a Congress ruled state, no, that is important, my lord.
Congress.
No, that is important for the purpose.
But you can raise when SIR is argued or something.
No, all the states together ruling, my lord, all the states across party lines has joined hands to deprive, my lord, whom? To the workers.
That-
And as Mr. Siu Singh,
The appreciation should come from your side that all of them have joined hands.
My lord, and it is a very unanimity in the country of various political parties, my lord, because one is Congress-led, one is AAP-led, one is DMK-led, one is BJP-led, my lord, but they are all unanimous, my lord, that the workers must be deprived of their rights. That is what, my lord, is very important. Normally, my lord, the industries would be
The
coming,
argument is non-political.
my lord, yes, my lord, what I'm saying, my lord, when, my lord, your lordship says there must be model employers. Now we see my lord, all the states across party lines are not model employers as such, my lord. That is what I'm trying to say. Now, Roman 4, my lord, at page 4. An argument is made that is work-centric, my lord, judgment. Bangalore Water Supply, worker-centric, workman-centric. My lord, I have quoted a recent judgment of your lordship's court, but the Industrial Disputes Act is a harmonious, my lord. It is for a harmony and cordial relationship between the parties, my lord. That is the purpose, my lord. It does not merely give certain benefit to the workman, as Mr. Siu Singh, it gives certain protection to the public utility services. You cannot, my lord, criticize a judgment saying that it's workman-centric, so change the judgment, my lord. And fifthly, my lord, the principle of stare decisis, it has been there for 48 years. My learned predecessors councils have said, my lord, in the volume 2, pages 261 to 271, I have tabulated 27 judgments quoted with approval, with the relevant quotations, my lord, which has consistently followed this. Only 2 exceptions, my lord, choir board, where it did not fructify, and in the present case, my lord, where the 5 honorable judges takes a different view, but only on the view, my lord, there also, my lord, lordship would give me two minutes on that, my lord. Whether lordship would give me a minute, my lord.
That objection has already been raised.
No, my lord, an argument has been made whether Bangalore Water Supply is 7 judges or 5 judges or 4 judges, my lord. What I wish to say, my lord, on 21st of July 1978, the bench dissolves. No judgment can be given thereafter, my lord, on behalf of the bench. So the 3 opinions, my lord, one by Justice Chandrachud and 2 by Justice Jaswant Singh are not the opinion of the court, my lord. They cannot be taken as an opinion of the court. Otherwise, my lord, 3 of your lordships were in the AMU bench. Your lordship said we did not have time. It could have been given today, my lord. The judgments could have been reason can it be given today? Why your lordships gave it, sat overnight and did it? Because the bench is not available. So the procedure which has been adopted by Justice Chandrachud and Justice Jaswant Singh by delivering an opinion on 7th of April 1998, my lord, is not an opinion of the court. Because it has to be.
This issue.
No, it is.
Why unnecessarily the names
No, it is.
refer to this issue is being rectified?
No, it is necessary. No, it is necessary, my lord, because on 3 occasions I have given the details.
All right, if it's necessary, we'll examine.
No, my lord.
Then no, please.
On 3 occasions, this court has said we did not have sufficient time. The bench is dissolving. Now, if this procedure is available, my lord, that it can be given after retirement of one of the.
It's all right.
My lord,
For us, there is a judgment by the honorable judges, and that's good enough for us.
and that's what I'm saying. It is.
Decision was given, only reasons were
No,
supplied.
it cannot be given, my lord. Otherwise, your lordships could have given judgments.
You can't say.
If I am not wrong, either Machi Singh or the other one, the reasons came 1 year
1
later,
year later.
laying down the law about the rarest of.
Minerva Mills, Vaman Rao and Bhim Singh, all three because of retirements of judges. Minerva Mills, Vaman Rao, Bhim Singh ji, all 3.
But your lordships keep the judgment when the bench is available, my lord.
What you do, just formulate your
argument here is.
Just formulate your points.
Very well. My lord, if your lordship kindly come to page 4, para 4, my lord. Para 5. I have said on the principle of stare decisis, judgment of this court in Bangalore does not require consideration because it has stood by the test of time. The 5, para 8 is important, Lord. Page 6, para 8. What are the principles to be applied for reconsideration, my lord? Your lordships are reconsidering it. Lordship has a jurisdiction to reconsider it. But what are the principles, my lord? I have stated 5 principles taken from earlier judgments, and they are, my lord, there should be clear and compelling reasons to do so. There is a fair amount of unanimity that the previous decision is manifestly wrong. It is demonstrated that the earlier decision was erroneous beyond all reasonable doubt. Merely because different view is possible or more reasonable view is possible is not an adequate ground for reconsidering the earliest opinion, or if due to lapse of time or changed economic scenario, it is imperative to have a fresh necessary. My lord, for the changed scenario, my lord, we have a new act, my lord, which is in place, which will take care of the new scenario, my lord, subject to challenge, whatever it is being done. But today we have a new act, my lord, which is in place. So, my lord, in my respectful submission, these principles have culled out from the various judgments which have mentioned there, my lord. So far as unanimous part is concerned, Lordship are saying that I may not go, but in Lordship, I'll request your Lordship to kindly go through this para 10, my lord, of which I have mentioned there, my lord. And this has importance because, my lord, otherwise the judges cannot give it, my lord, after the retirement of one of the honorable judges, and that becomes the ground for review. The ground for review of 5 judges is the Justice Beg did not have the opportunity to look into the judgments of the other 2 honorable judges, my lord.
Yes.
And in any event, my lord, in view of the Trimurti pregnancies, it will be deemed to be a judgment of the 5 honorable judges, my lord, 7 honorable judges, and not, my lord, of any smaller bench by that.
All right, thank you.
And one last sentence, my lord, that all the 4 honorable judges, my lord, who has given the opinion, they have said these tests are till superseded by legislation, my lord. Now today we have a different legislative scheme, my lord, and there is, my lord, only due to pending cases, my lord, Lordship may not consider it to reconsider it, my lord. In any event, if a Lordship has to say, it will protect, my lord, all the pending litigations also, my lord. If anything
All
comes, my
right,
lord, then
thank
it will
you.
be.
Thank you, Mr. Ansari. Thank
I'm
you.
grateful to your Lordship.
Yes, Mr. Gopal.
May I please, Miss? I'll keep it brief because I adopt all the arguments of Ms. Jai Singh and Ms. Chandra Singh. I think they've covered most of the field. I think in fairness, the Attorney General in his written submissions also has conceded that the triple test is not something that they're taking a cavil with. So really the scope, I believe, that we have to address is in a very narrow passage. And I just want to address on those 2 aspects. One is about the sovereign/public function. The other is about the charitable aspect. Now, the charitable aspect, there is an exception that's been carved out in Justice Krishnar's own judgment, which Justice Chandrachud agrees with, which is on the limited aspect of those clubs. Justice Krishna draws a distinction between clubs like the Madras Gymkhana Cricket Club, etc., and those, he said, which are the small clubs, the community clubs by young men and women that they form for their own evenings, etc., where it's actually self-serving and the key is held with the secretary, those guys. So he says only that aspect of clubs will he be excluding. Now, I just want to address, and I believe the test, I've just handed up my written submissions, just 2-3 paras here and there that I want to read out to your Lordship. One is, if your Lordships will just have that, it's in volume 6 is where the written submissions are. There's hard copies and soft copies.
Oh, we have on the
Yes.
screen. So paragraph.
Page 4 of my submission, subpara D, small d. I'm taking my first 2 Roman numeral submissions as read. I will not read that again.
All of this being so. Mr. Gopal.
All of this, yes.
Volume 6.
In volume 6, Manoj, there's a bunch of written submissions.
Right.
Mine, I understand, is serial number 8 in that.
That's on the screen.
In the respondent's file, it's written, it's volume 8. Hard copies have also been given, but it's volume 8.
It is on screen.
It's on the screen.
Yes.
Being
Yes.
so, the
If I can
approach
just,
that,
if I can just read that, it's on the screen as well. All of this being so, the approach that would be commended, all of this I'm referring to, Manoj, is the background that eventually it's about industrial harmony, Article 19(1)(g) and 21 rights of both the employers and the employees, not only on workmen's interest, because that is an issue that can fall either way. So keeping all that in mind, adjudicatory process, penalty process, everything that Ms. Jai Singh said, because she's got the experience of 50 years, which I don't have in this area. All of this being so, the approach that would be commended in considering whether an activity is industry for the purpose of Section 2B could be as follows. 1, to examine only the activity, which is what the new section is. The word used now is activity. To see whether it comes within the width of the words undertaking, calling, or avocation, which are the widest phrases employed in the provision. In 2J, these 3 words are the widest among those. 2, to ignore who is carrying out the activity concerned, because that is not germane to the purpose of industrial regulation. 3, to ignore the motive behind the activity as long as it is legal. A charitable activity cannot be permitted to be unregulated. As a result, it is perhaps the judgment of Chandrachud J, as he then was, at paras 175 to 182 that provides the most logical and consistent approach in interpreting the provision without the artificial exceptions carved out by IRJ. Just two paras of Justice Chandrachud I want to read because it's now 9 judges. So I believe that there is a refreshing consistency in those two paragraphs, which I mean, I grappled with it, but I found it difficult, not only because of Justice Iyer's language, but also the kind of nuances that are drawn. For subsequent interpretation, it becomes difficult, though it has been followed. If I can just take your lordships to the BWSSB judgment. This has not been read to your lordship, so if I may just read that. Para 175 of the judgment, which volume 5, capital B, 75. Yes. This is page 85
But have,
of volume 5B. I'm sorry, ma'am.
but having thus expressed.
But having, I just thought if I could just read 174 above, they are referring to Hospital Mazdoor Sabha, and in that context, in para 174, the court expressed its opinion in a characteristically clear tone by saying that if the object and scope of the Industrial Disputes Act are considered, there would be no difficulty in holding that the relevant words of wide import have been deliberately used by the legislature in defining industry in section 2J. The object of the act, the court said, was to make provision for the investigation and settlement of industrial disputes, and the extent and scope of its provisions would be realized if one were to bear in mind the definition of industrial dispute given by 2K and the other definition. I'm not reading all that. If I can just come to the last bit, it is the character within courts of the activity which decides the question as to whether the activity in question attracts the provision of section 2J. Who conducts the activity, said the court, and whether it is conducted for profit or do not make a material difference. But having thus expressed its opinion in a language which left no doubt as to its meaning, the court went on to observe that though 2J used words of a very wide denotation, it is clear that a line would have to be drawn in a fair and just manner so as to exclude some calling, services, or undertakings from the scope of the definition. This was considered necessary because if all the words used in the definition were given the widest meaning, all services and all callings would come within the purview of the definition, including services rendered by a person in a purely personal or domestic capacity or in a casual manner. The court then undertook for examination what it euphemistically called a somewhat difficult problem to decide, and it proceeded to draw a line in order to ascertain what limitations could and should be reasonably implied in interpreting the wide words used in 2J. I consider with great respect that the problem is far too policy-oriented to be satisfactorily settled by judicial decisions, and it says, and the Lordship observed the Parliament must step in. The next page, about 6 lines down, where it says the court ultimately drew a line. Next page, Manoj. The court ultimately drew a line at the point where the regal or sovereign activity of the government is undertaken and held that such activities of the government as have been pithily described by Lord Watson as the primary and inalienable functions of a constitutional government could be stated negatively as falling outside the scope of 2J. The judgment concludes with the summing, etc. Last 4 lines of that para. Seeds of many a later judgment were sown by these limitations, which were carved out by the court in order to reduce the width of the definition, which was clearly described as having been deliberately couched by the legislature in words of the widest amplitude. These exceptions which the court engrafted upon the definition of industry in 2J in order to give to the definition the merit of reasonableness became in course of time as many categories of activities exempted from the operation of the definition clause. To an extent, it seems to me clear that though the decision in Hospital Mazdoor Sabha that a government-run hospital was an industry proceeded upon the rejection of the test of nociter associates, it is this very principle which constitutes a rationale of the exceptions carved out by the court. It was said that the principle of nociter is applicable in case of doubt, and since the language of the definition admitted of no doubt, the principle had no application. But if the language was clear, the definition had to be given the meaning which the words convey, and there can be no scope for seeking exceptions. The contradiction, with great respect, is that the court rejected the test of association of words while deciding whether the government-run hospital is an industry, but accepted that very test while indicating which categories of activities would fall outside the definition. The question then is if there is no doubt either as to the meaning of the words used by the legislature in 2J or on the question that these words are of amplitude, what justification can one seek for diluting the concept of industry as envisaged by the legislature? On a careful consideration of the question, I am of the opinion that Hospital Mazdoor was correctly decided insofar as it held that JJ Group of Hospital was an industry. But respectfully, the same cannot be said in regard to the view of the court that certain activities ought to be treated as falling outside the definitional clause. I don't want to keep reading further, but the next para was dealing with government function. It's very important. It's central to my argument. So please read that when your lordships have time, which is para 179. Para 180 deals with charitable, and para 181 deals with solicitors. And finally, my lords, last part of para 181 deals with clubs. And para 182 with charitable, 182, if in the margins your lordship can note, para 119 of Justice Krishna, because it's agreed to that the limitation on charitable is only that limitation which Justice Krishna has drawn. My Lord Justice Chandrachud adopts that as well, which is the self-serving being excluded. So in my view, this is a cohesive judgment which captures what I believe would be our argument. If for a minute I can take you back to my note. So this is what I want to say with reference to both charitable as well as governmental functions, sovereign functions. These are for industrial harmony. So it doesn't matter across the board. And for an idea of what we are dealing with, my lords, the kind of cases your lordships have been dealt with here in the petitions before your lordships, you're dealing with 3 temples, 1 Gaushala, and states. That's what you're dealing. Interveners have come, which are a few hospitals, AIMS was heard, etc. But this is really the compass of who your lordships are dealing with. So these large industries, etc., which we have in our mind, they are not here either as petitioners or interveners. I just want to clarify that. Now, just in my note, my lords, if your lordships will come for a minute to page 8, which is the first annexure to the note. Huh? Page 8, this is the first annexure. This we have comprehensively looked at all the Supreme Court judgments from the inception, and because it's color coded, at least in it's color coded, your lordships will see this is from the beginning, from D.N. Banerjee onwards. If your lordship sees the extreme left, it gives you an idea of what are the departments and organizations, municipalities, like the just Datta has it first. Yes, that one. So the pink ones, my lords, are where it's not an industry. That's what your lordships have held. Green, eventually, your lordship will find is BWSSP, and thereafter, there have been as many as 27 cases where your lordships have applied BWSSP, one way or the other. Now, I believe that Justice Chandrachud's view is the best view, but your lordships have been applying Justice Krishna's majority view throughout. And this, the reason why all of these are set out is so your lordships have a flavor at the extreme left of clinics, municipalities, irrigation departments, education institutions, etc., immediately after BWSSB. And where there has been a decision one way or the other. It's not that the workmen have always succeeded. Many times your lordship have decided some are not industries applying this test. Therefore, the next page after that at page 13 are the list of the High Court judgments. And these High Court judgments, which are the ones which have followed BWSSB. In that, there are 66 of them. The reason I mention this, my lords, is if your lordships will come to page 25, 2 paragraphs, one of a 7-judge decision, a unanimous judgment of penned by Justice Gajendra Gadkar on how stare decisis with reference to decisions which are already made. It's a completely different matter where it's coming up for the first time. Where a decision is already made, there's a small exception that they've carved out with reference to the number of judges. I'm just drawing that to your lordship's attention. One sentence at page 25. This is in Keshav Mills in 1965. About 20 lines down, it's right in the middle of the page of page 25. I've put that extract out. This is Justice Gajendra Gadkar speaking for a unanimous bench. But different, it's underlined, but different considerations must inevitably arise where a previous decision of this court has taken a particular view as to the construction of a statutory provision. As for instance, section 66(4) of the Act, when it is urged that the view already taken by this court should be reviewed and revised, it may not necessarily be an adequate reason for such review and revision to hold that though the earlier view is a reasonably possible view, the alternative view which is pressed on the subsequent occasion is more reasonable. about 4 lines further where it's further underlined. Frequent exercise by the court of its power to review its earlier decisions on the ground that the view pressed before it later appears to the court to be more reasonable may incidentally tend to make law uncertain and introduce confusion, which must be consistently avoided. And then 3 lines later, the court must be satisfied with a fair amount of unanimity. I'm saying among this 9-judge bench, there must be a fair degree of unanimity on it. It's not simply a matter, because we've seen this in the past, fair degree of unanimity among its members that a revision of the said view is fully justified. And then concluding next page 26, is the court, third line, is the court hearing such plea fairly unanimous that there is such an error in the earlier view? These are the questions to be looked at. What would be the impact of the error on the general administration of law or on public good? Has the earlier decision been followed on subsequent occasions, either by this court or by High Court? And would the reversal of the earlier decision lead to public inconvenience, hardship, or mischief? Of a similar nature is the next judgment extract. That's Vaman Rao, Justice Chandrachud speaking for 4. Justice Krishna agrees with him on that. It's in the same page. And then one last thing I want your lordships to see, which is page 45. The very last page of that, if your lordship have the hard copy, it's absolute last page, annexure F. If your lordships were to exclude from sovereign functions these industries, which are, for example, defense research institutes, military clubs, Ministry of Defense, Home Affairs, Forest, etc., the posts on the extreme right will all cease to be workmen for the purposes of the definition of the Act. Because the Act says the workman has to belong to an industry. If the industry goes, the workman goes. So the workman's rights under the Act are inextricably tied up to it being an industry. So all of these people, gardeners, cleaners, doormen, drivers, etc., all of them would be completely excluded. I don't believe, my lords, that that would be the reason why your lordships would revisit this. And then finally, my lords, I'm just taking your lordships back to the note right at the beginning. Page 6 of the note. I have taken your lordships, I'm just taking your lordships, bottom of page 5, Roman 5. I'm just referring to the questions that your lordships have framed. So on question 1, which is the triple test, I have pointed out the page number where it's been accepted, and really that's not too much of an issue today. Question 2, and I also adopt everything that Ms. Jaising said, that all 3 limbs, etc., have been adopted in the law as it stands, so it's a consistent position. Questions 2 and 3, which are sovereign social welfare, are dealt with under Roman number 5. Your lordships may take that as read. I just want to point out one small thing, that in Justice Krishna's judgment conclusion, para 143, small b, is where that exception is carved out for the sovereign functions, para 143b. I believe that that para 143b does not take into consideration the 9-judge decision that Mr. Chandrachud Singh referred to yesterday on that legal remembrance, so your lordships will recall. Now, legal remembrance, I have a separate note, which is annexure E to this, which gives you the entire history, but I'm not taking you through it, on how that came to be. From 1961 in the earlier Calcutta case, applying the common law principles of how sovereign states, etc., are not bound by statute. Justice Vanchu gave a very stinging dissent in that case. That Justice Vanchu's dissent effectively became the majority in legal remembrance. And legal remembrance effectively stays, because that was a case where a market was set up by the state of Bengal in Calcutta, without licenses, without following the law. Penalties were imposed, and in legal remembrance, the 9-judge bench says that the state can't wriggle out. The statute applies to them. Either express reference saying that it applies to you is not necessary, which was the earlier view. That was overruled. So when the statute does apply to you, and the statute makes no exception to you, not in the section at all, and nowhere else there's an exception. In fact, it is only like employer definition in the Act. Shockingly refers only to government employers. It doesn't refer to private employers at all. But perhaps it's giving clarity about who will be the employer for the purpose of governmental authority, state, etc. So because of that, this BWSSB judgment, before making that exception for sovereign, should have considered that the binding law binding the 7-judge decision was a 9-judge decision, which said that it binds the state. Statutes bind the state unless there's an express exception. There is no express exception in the statute. Now, the second aspect and the last aspect that I have to say on this is this, that the lack of an alternative remedy to those who may not be deemed to be industries was the reason why the 1982 statute was not notified. This was taken note of by your lordships in the 5-judge to 7-judge reference in this case in 2005. I've referred to the 2 paragraphs where Ms. Jaising in fact had referred to the Ultimesh rain line and said that, look, they have not notified it, please, it should be notified. The response is, we don't have, Union of India's response is that we don't have an alternative remedy. The paragraphs of a separate, paragraphs of the affidavit of the Union of India is in fact extracted in a separate judgment. I'll hand up copies. This is a Gajanan Maharaj Sansthan, which I think was referred to yesterday. Just give copies. The entire affidavit of the Union of India is extracted, where they refer to the fact that we don't have alternate remedies for these other industries. That is why I have not notified this. If I have notified this, those who are excluded will have no remedy available. Now, this is the consistent position why that 1982 amendment didn't come into force. I'm not reading that. Now, that is why there's a lack of alternate remedy if your lordships were to limit the definition of industry. One last thing, Manoj. I think 3 of your lordships were there in the Tejpal batch dealing with that section 24(2) of the Land Acquisition Act. And the fallout of that,
Entire bench.
the entire batch, Justice Datta knows this, last week.
Entire bench. That were 3 judges.
Entire bench, yes. You're sitting alternately, Manoj. Now, there we've had this fallout coming, Manoj, where petitions still keep coming on this. I just want to caution one thing, that whatever your lordships declare one way or the other, please make it prospective, because all these decisions, these 100 decisions of High Courts and Supreme Court, we don't want that to be brought up now like it was brought up in those cases saying, oh, Indore municipality has come, so we are filing appeals after 3,000 days, 4,000 days, etc. Whatever your lordships declare, please declare it prospective from the date of this judgment, and will hold the field for 2J. We have, as I mentioned to your lordships, I am appearing for the All India Trade Union Congress. We have nearly 1.4 crore workers, etc. We have challenged the provision of the new code, the definition, to that limited extent, which I'm also arguing here, so there's an overlap. So please also, that one other caveat, Manoj, I mentioned it in my note. Just please save our challenge, let that not be, whatever manner. Huh? Oh, it's listed tomorrow is what I understand, but please say that. Most grateful, ma'am. Most grateful.
I may go next. That is why there is explanation
Yes, ma'am.
to Order 47, Rule 1.
Yes.
A subsequent change of law will
Yes.
not touch upon the already delivered judgment.
I argued that unsuccessfully, ma'am.
No, I
Yeah.
thought they are.
No, I know. But when we argued it, we were hoping that Manohar Lal line would not be implemented, but that should have taken up. I'm grateful. I'm most grateful.
If I may go next.
Otherwise, there's no finality in anything.
Exactly.
And that is not rule of law. also.
Can be taken up in
Yes.
There is a continuation of the list.
Continuation of the list.
That was in fact arising from your lordship's reference because of the difference of opinion. It went to the 3 judges.
Review, you can
Yes.
take it later on in an appeal.
Yes, ma'am. Yeah.
It's an appeal.
My ladyship may take it up privately with the authors of the judgment. I'm grateful.
Yes, please.
I won't repeat anything because my points, of course, I have given a note.
5 minutes, please.
Definitely, Milo. I have given a note, Milo, in volume number 6, Milo. That is not circulated also.
May I be excused, my lords? I'm sorry. I'm great.
All the points except 2 aspects are covered, Milo. Indira Jaising and C.U. Singh, Milo. And of course, now Shankara. One aspect, Milo. We know that, Milo, we are not going into the new code for interpreting the provisions, Milo. But one fact remains, Milo, because of a judicial notice. Despite the clamoring, the plea for expansive reading of sovereign function and to equate sovereign functions with government functions, Milo, there is no such a provision in the new code. So that means the parliament and the government is accepting the provision only for that purpose. So when they accept law and that position continued for the last almost 50 years, Milo, there cannot be any plea for reconsideration by the government at least. So that is one aspect, Milo. And consciously Parliament avoided that Milo. They only said that related to the sovereign function. There is no government function, welfare activities, nothing like that. Even the present code 2P, Milo. So that's one aspect. Secondly, Milo, regarding large number of more than 2 million of employees, so-called scheme employees, workers, Milo. They are working under different departments. They have no avenue for relief, Milo. They are not under Article 311, no other remedies. So necessarily, Milo, if they are removed from the concept of industry, Milo, definitely there will be severe miscarriage of justice. We are not for employees coming under 311. Our so departments, of course, they are now engaging workers because most of the agriculture colleges, universities, they have got farms. Large number of farm laborers are being employed or engaged. So they should come under this concept of industry. Otherwise, there is no remedies at all. So I referred to this aspect in page number 6, 2, 3 and page number 8, clause 7 below. These are my basic concerns below. Obligement. Thank you for.
Thank you. Thank you, Mr. Surendra.
My lords,
Yes,
I
madam.
in this matter, my lords, I have just circulated my note. My lords, in this matter, I have just circulated my physical note, my lords. My lords, I appear for an organization that works with sanitation workers and workers engaged in sewage cleaning and manual cleaning. Though they are, though it is supposed to be prohibited, the fact is that they are still engaged by both municipalities and private parties to engage in sanitation work. Now, my lords, I have two main arguments. The first one in my note, if my lords may see, if my lords have to decide the meaning of the definition of industry, I would argue, to build on what has been argued before, is that we have to take a purposive approach. Now, a purposive approach of interpretation, of course, my lords are very familiar with. In fact, even starting from D.N. Banerjee in para 1.2, D.N. Banerjee itself in the judgment said that the ID Act, the meaning should be ascertained from not only the words employed in the definition, but also the setup and context to ascertain really what was meant to be conveyed. My lords, purposive interpretation to really focus on what is the object of the legislation. My lords, our Supreme Court in ERA versus State of NCT also, the issue, in fact, they quote where the concept of purposive interpretation came out, and I quote Justice Learned Hand's observation that was there in para 1.3. What this Honorable Supreme Court, my lords, I think it was Justice Deepak Mishra's decision, and I quote, "Of course, it is true that the words used even in our literal sense are the primary and ordinarily the most reliable source of interpreting the meaning of any writing, be it a statute, a contract, or anything else. But it is one of the surest indexes of a mature and developed jurisprudence not to make a fortress out of the dictionary, but to remember that statutes always have some purpose or object to accomplish, whose sympathetic and imaginative discovery is the surest guide to their meaning." So, my lords, ultimately, what is the meaning and object of the ID Act? The meaning and object of the ID Act, my lords, my submission, if we look at the BWSSB judgment of Justice Krishna Iyer, is to protect workers' rights. Though it is on industrial disputes, yes, to ensure that industrial disputes maintain industrial peace, but ultimately remedies were there to protect workers so that they are not left remediless. And my lords, para 18 of the judgment in BWSSB, I have extracted at para 1.5 of my written submission. To sum up, where Justice Krishna Iyer summarized it, to sum up, the personality of the whole statute, be it remembered, as a welfare basis, it being a beneficial legislation which protects labor, promotes their contentment, and regulates situations of crisis and tension where production may be imperiled by untenable strikes and blackmail lockouts. The mechanism of the Act is geared to conferment of regulated benefits to workmen and resolution according to a sympathetic rule of law of the conflicts, actual or potential, between management and workmen. Its goal is amelioration of the conditions of workers, tempered by a practical sense of peaceful coexistence to the benefit of both, not a neutral position, but restraints on laissez-faire and a concern for the welfare of the weaker lot. Empathy with the statute is necessary to understand not merely its spirit, but also its sense. One of the vital concepts on which the whole statute is built is industry. And when we approach the definition in section 2J, we must be informed by these values. My lords ask the question that the route to workers' rights is through the industry, through the definition of industry. Yes. But the core of the object of the act, my submission is that it is to protect workers' rights. And from that aspect, if we were to look at the definition of industry, then I would submit, my lords, in fact, many of the other decisions I've relied on, again, elaborate on the aims and objects and intent of the ID Act. I don't want to reiterate. I have Mohammad Ali versus State of Himachal Pradesh. Again, it reiterates that it is a welfare legislation to protect employees from arbitrary retrenchments.
There is no doubt on it.
Yes. So I will not reiterate those. Ajay Singh, all of those reiterate. Then, my lords, in addition to looking at the meaning of the ID Act, in para 1.9, my lords, in BWSSP, the court also said that the Industrial Disputes Act has to be interpreted using the lens of Article 38, 39, 42, 43, 43A of the Directive Principles, because these articles of the Directive Principles also protect the rights and welfare of workers. Of course, all of those are reiterated. We protect the adequate means of livelihood, health and strength of workers, just and humane conditions of work, because all of those conditions are there in the ID Act. To 43 says that to all workers, industrial or otherwise, work, a living wage and conditions of work, and 43A also. So how do we ensure that our definition, my lords, takes into account the meaning given under the DPSPs as well? Now, my lords, that is my first submission. If we were to take that as our purposive interpretation and guidance, certainly the definition we would want to give to industry would be a wide, broad-ranging definition and not a narrow one as argued by the petitioners. Now, my lords, the second point on excluding of the sovereign function. Now, exclusion of the sovereign function, my lords have raised that issue. In BWSSB, para 143, para 143 makes a very narrow exclusion of the sovereign function. And may I just read out para 143, which I've extracted. The dominant nature test, where a complex of activities, some of which qualify for exemption, others not, involves employees on the total undertaking, some of whom are not workmen, as in the University of Delhi case, or some departments are not productive of goods and services if isolated. Even then, the predominant nature of services and the integrated nature of departments, as explained in the Corporation of Nagpur, will be the true test. The whole undertaking will be industry, although those who are not workmen by definition may not benefit from status. B, my lords, notwithstanding the previous clauses, sovereign functions strictly understood alone qualify for exemption, not the welfare activities of economic adventures undertaken by government or statutory bodies. Then they talk about severability. Here I want to focus on sovereign functions strictly understood alone. My lords, my ladyship asked, what is the, in understanding sovereign functions, a question was raised, what about LPG? And how do we look at it in the context of the increasing privatization? My lords, sovereign functions has been largely understood to mean those functions which cannot be privatized. Today, my lords, almost all functions of the state are privatized. Health, education, water, in many all other functions are privatized. But then sovereign functions would be those limited functions which cannot be privatized, and my lords, or cannot be alienated by the state to private parties. And my lords, one decision that looked at industry from the context of sovereign functions, which has not been referred, is the 2000 APMC versus Ashok Hirakuni case. And my lords, that is already there in volume 5. Could I please request if volume 5 can be seen? At para, this is at volume 5, already filed, 3944, para 21. That was exactly the issue raised. What as for sovereign functions, and how would the definition of industry under BWSS will it be curtailed or not? And in para 21, if I could read out, it's at page 3944 of volume 5. In other words, my lords have found.
Yes.
In other words, it all, and here, my lords, the issue was whether APMC, the Agricultural Produce Market Committee, whether that would be industry. Argument made was the market is being regulated by the state, and therefore it falls within sovereign functions. The court denied that contention. And my lords, para 21, in other words, it all depends on the nature of power and the manner of its exercise. What is approved to be sovereign is defense of the country, raising armed forces, making peace or war, foreign affairs, power to acquire and retain territory. These are not amenable to jurisdiction of ordinary civil courts. The other functions of the state, including welfare activity of the state, could not be construed as sovereign exercise of power. Hence, every governmental function need not be sovereign state activities. Sovereign state activities are multifarious, from the primal sovereign power, which exclusively, inalienably could be exercised by the sovereign alone, which is not subject to challenge in any civil court, to all the welfare activities which would be undertaken by any private person. So merely if one of the employee of statutory bodies would not take it outside the Central Act, if that be so, then Section 2A of the Central Act, read with Schedule 1, gives a large number of statutory bodies which should have been excluded, which is not. Even if a statute confers on any statutory body any function which could be construed to be sovereign in nature, would not mean every other function under the same statute to also be sovereign. The court should examine the statute to sever one from the other by comprehensively examining various provisions of that statute. In interpreting any statute to find if it is an industry or not, we have to find its pith and substance. The Central Act is enacted to maintain harmony between an employer and employee, which brings peace and amity in its functioning. This peace and amity should be the objective in the functioning of all enterprises. This is to benefit both employer and employee. Misuse of rights and obligations by either or stretching it beyond permissible limits have to be dealt within this framework, but endeavor should be in all circumstances to not to exclude any enterprise from its ambit. Para 22, they refer to Nagendra Rao. My lords, Nagendra Rao was the whole line of statutory sovereign immunity.
Yeah, this is
And-
non-principles. You can
Yes.
proceed
Then,
further.
my lords may just refer to para 29 of the same decision. Para 29. Para 29 refers to 2A, which was referred how many central government industries and statutes are all covered. 30, my lords. Para 30. From the aforesaid catena of authorities, inalienability, this is what I raised, my lord, that it cannot be alienated. Inalienability is one of the basic character of sovereignty.
This has been argued.
Yes, I will just highlight one more para. The Encyclopedia of the American Constitution with regard to sovereignty attempts to define it. And then, my lords, 31. Words and para. The sovereign powers of a government include all powers necessary to accomplish its legitimate ends and purposes. Such powers must exist in all practical governments. These are the incidents of sovereignty of which a state cannot divest itself. And then they go on to exercising the right of taxation by the right of eminent domain or through its police powers. 32. So sovereign function in the new sense may have very wide as primary inalienable functions. Broadly, it is taxation, eminent domain, and police power, which covers its fields. It may cover its legislative functions, administration of law, eminent domain, maintenance of law and order, internal and external security, grant of pardon. So the dichotomy between sovereign and non-sovereign function could be found by finding which of the functions of the state could be undertaken by any private person or body. The one which could be undertaken cannot be sovereign function. So therefore, my lords, the test for sovereign function is what cannot be alienated.
Yeah.
And therefore, if we limit it to that, the limits of sovereign functions or the sovereign functions which could be excluded are very, very limited. Thereafter, my lords, I will not reiterate a whole range of cases from the Nagendra case.
There is no
Statutory immunity was also limited. I will not reiterate. Finally, my lords, at para 2.9, Ms. Jaising also raised the issue of data. In fact, in 2002, there was a National Labour Commission report, which in fact gave its recommendations after a detailed study all over the country. And ultimately, the recommendation given, which is available, my lords, is that they recommended that in fact, the entire definition should only be under establishment. All workers, including government workers.
Yeah.
And one of their recommendations is, my lords, I've culled out, one of the most important steps that one needs to take in rationalizing and simplifying existing labor laws is the area of simple common definitions. Such terms include worker, wages, and establishment by making the law applicable to establishments employing 20 or more workers, irrespective of the nature of activity in which the establishment is engaged. So therefore, all workers, government, private, charitable, even domestic workers were to be included, and the whole concept of sovereign function or the exclusion is sought to be completely minimized or nullified. And therefore, my submission is, my lords, in this light, if we both define industry, then we don't need any change from the definition, and therefore it can cover a wide range of workers.
Thank you, madam. Thank you very much. Dr. Singh, you want to add anything?
May I please, Madam? My lord, the state is obliged to carry out welfare activities as mandated under scheme of Part 4, Directive Principles of State Policies, my lord. The union as well as state, they have argued, my lord, that the workmen, which is defined by Section 2S, working in the industry, which is defined by Section 2J, the industries which are performing governmental functions, they want that those industries should be declared as sovereign functions, and the workers working there, they should not get the labor law rights, my lord. This is the sum and substance of their argument, my lord. Firstly, Part 4 of Constitution is for the weaker sections, my lord, to protect their rights, my lord. So, in the garb of applying directive principles for the welfare of have-nots, the state cannot ride on the shoulders of the other have-nots, depriving them of their legitimate rights while ensuring DPSPs for one set of have-nots, and the state cannot deny and deprive another set of have-nots, my lord. That is the basic principle which, my lord, this honorable court should consider, my lord. The Industrial Disputes Act, my lord, is enacted at a time we were not independent at that stage of time. And the definition, Section 2A, which define appropriate government, my lord, it recognize central government entities, and the central government has been declared as appropriate government, my lord. Though Section 2A has been read, my lord, after our independence, we got fundamental rights. We got directive principles. So any interpretation which this court is giving today should take into account the changed circumstances, because at that time, these rights were not there. These directive principles were not there. But still, these directive principles and fundamental rights which have come by way of our constitution, they should be protected and preserved by this honorable court. The industries which are mentioned in Schedule 1 of this Act, my lord, as Mr. C.U. Singh has explained a little bit, my lord. So those industries are all government industries. So the way the interpretation is being asked by the appellants of central government or the state government, my lord, that is contrary to the scheme of the Act. The scheme of the Act require that there should be industrial peace. To maintain that industrial peace, the workers and the industry and their rights have to be harmonized, my lord. And there is a scheme in the Act, my lord, according to which if the industries maintain certain rights, these rights are maintained, then there will be industrial peace, my lord. My lord, there are situations when in those situations the lockout and other problems arise in the industry, my lord. This act was enacted to take care of that situation, my lord. Suppose, my lord, decide that these are sovereign functions, then these workers will have no rights. Firstly, they will have no rights. Secondly, suppose they will have rights in civil court, though that is barred, But if they are going, then that is not a full remedy, my lord. Then if they go to High Court, my lord, the High Court also, then a function which is discharged by a labor court at a lower level will be discharged by a High Court. And in this manner, the functioning of the High Court will be affected. And the judicial review, which is the basic feature of our constitution, my lord, and that the common man who is coming directly to the High Court without any alternative remedies, in that situation, my lord, the remedies which are not available to the workers, there'll be unrest and a opinion against the constitutional courts, my lord. So, with the respect, my lord, I contend that the court should take into account that the High Court dockets are not clogged, so that the workers may have a remedy. That remedy.
Got your point, Dr. Chauhan. According to you, the denial of platforms under the ID Act
Yes, my lord.
will ultimately compel them to approach the High Court under
Yes, my lord.
26 also, and that it will amount to denial of access to justice.
Yes, my lord. Like, my lord, this parliament has enacted Administrative Tribunal Act. Earlier, there was a direct SLP to this honorable court. Then this honorable court has to decide L. Chandra Kumar, my lord. Thereafter, the jurisdiction of the High Court has been created for those cases. So, my lord, there are situations where this honorable court has to take into account the directive principles, like in Article 38, there is a mandate to the state to secure social order for the promotion of the welfare of the people, my lord. So, as Ms. Jaising has stated to this honorable court, all the parties who are ruling in this country, their government have taken a stand against the workers. The workers who are discharging the essential functions, because without them, the industries can't work. And if the industries can't work, then that type of situation which we are creating in the society will affect the social harmony in general also. Not only in the industrial piece, but in general also there will be disturbances, my lord. Then Article 39E provides, my lord, the workers should not be forced by economic necessity to enter avocations unsuited to their age and strength. So, if there is no alternative remedy, then the workers, they are getting some pay which is lower than the minimum wage, they will have no remedy. Some worker are getting higher pay, some worker are getting less pay. So there will be disparity in the pay. There will be no remedy for them to approach to a court, my lord, or in the industrial tribunal, my lord. Then, my lord, there are directive principles which mandate the state to carry out the welfare activities. These welfare activities cannot be considered in such a way that one set of the people, they will get that benefit by denying another set of the people. And such obligations, which are obligation of the state, those obligations cannot be minimized, because whatever resources are there with the state, with those resources, it is their bounden duty under the scheme of the constitution to ensure them those dignified rights, my lord. Then, my lord, in the Bangalore water supply, only 3-4 paragraph, my lord, I wanted to explain.
You can point out the paragraph.
Yes,
We've
ma'am.
already read that judgment many times.
My lord, Justice Krishnayer's para 140 to 144,
Yes, one,
and Justice Beg's judgment, my lord, para 160, my lord,
160.
160 and 163, my lord,
Hold on.
and Justice Chandrachud's judgment 178, my lord,
178 years. Today only read before us. Yes.
and my lord, this the dissenting judgment is also not completely dissenting, my lord, because that is practically concurring, only some explanation is there. So,
For para 185.
185, 186, my lord. My lord, so far as the triple test is concerned, my lord, and the new legislation which, my lord, are not testing today, my lord, in whatever evolved in Bangalore water supply, my lord, in the new act, those industries have been placed in exception. So there'll be no rights, my lord. My lord have to interpret in such a way that, my lord, suppose it is a charitable institution, then there are certain functions which are charitable, and if that charitable institution is not is working as industry, those spheres should be excluded, and they should not be part of the charitable institutions, my lord. With all this, my lord, my lord, concur with Ms. Jaising and Mr. C.U. Singh, because they have covered all the areas, my lord. And I personally feel that the Bangalore water supply is correctly decided with this interpretation, because the charitable and other things which they are excluding, my lord. I hope this honorable court will consider it in such a way that the rights of the worker will not be marginalized in the future legislation, though it is in action now. And those rights which are created by that legislation, my lord, should protect the dignity of the workers working, and they should have an alternative mechanism to go to a adjudicatory authority or a industrial tribunal. With this, I am grateful to my lord for this.
Thank you, Dr. Swan. If any one line you can add.
I will add only one thing.
Please,
I will add only one thing, my lord. Lordships are considering the definition of industry, where the aspects have been taken from the industrial side. My lord, the point is the nature of work performed by the workman has to be taken, and for that purpose, and the immunity, your lordships, two things. For that purpose, my lord, I have found a judgment of the Supreme Court. I will circulate it, in that the immunity has to be seen vis-a-vis the work. Here, my lord, one more.
like this.
Just explain one thing. Here the lady was working in a, here the lady was working in a, embassy in the United Kingdom. There the lady's services were terminated, my lord. So the court went into the nature of the work, what work she was performing, and whether they were connected with the immunity or not, because the authority claimed the immunity. So in that purpose, the court went to the nature of work of the workman, and for that purpose, may I lord, I circulate the judgments, your lordships. For if your lordships want me, I will read, otherwise your lordships.
You can circulate it along with a brief note. And please first you read it and identify the relevant paragraph and then circulate with a note. We will definitely go through it. Yes, anything?
Yes, your lordship.
Please, my lord.
Yes, you want, yes.
Yes, your lordship. Your lordship,
One line only,
I'll take a little more time.
more than that.
Malas, I'll take one
Yes.
line if.
I'll just take a few minutes, your lordships. I'm conscious of the limitation of time. Your lordship, the main issues that I'm seeking to raise, although have been covered in extenso by my senior colleagues, there's just one aspect which I wish to invite your lordship's attention to, and that in my respectful submission will have some bearing on the matter. Your lordship, the Industrial Disputes Act, which we are concerned with, is traceable to entry 24 of list 3, your lordships, whereas all other statutes which have been ancillary referred to in this particular course of hearing are traceable at best to entry 2024 of the list, your lordships, particularly shops and establishments of list 3, your lordships, of the mainly the Shops and Establishments Act. So it is my respectful submission on two aspects. First, your lordships, that the Industrial Disputes Act, which is a pre-independence act, a few months prior to independence, came in April 1947. The legislature was absolutely clear, and the Constituent Assembly debates also reflect that intention, that this is within a standalone silo that they have placed it. And they have not sought to then place any other act, such as the Shops and Establishments Act, which has come for different states in different years, your lordships. They have not sought to place it in that particular way, so that they are clear in their understanding that the Industrial Disputes Act with a standalone entry will cater to all of this. That's argument number one, Your Lordships. The argument number two in this extension that I wish to make is that the Industrial and Disputes Act should not be seen as overlapping in any manner, but supplementing the cause. And therefore, to that extent, when the states are ad idem in arguing that please do not have these workers move towards the Industrial Disputes Act, there are equally efficacious remedies which are available under different statutes, which are available under different enactments. That argument, in my respectful submission, needs to be rejected at the outset. Your Lordship, just building on that, and there were two observations which fell from the bench, and I'll just address it quickly on that aspect, and I'll leave it at that, Your Lordships. The states are ad idem and particularly advancing this argument that please do not have the worker opt for the ID Act. The worker can opt for the Shops and Establishment Act. The worker can opt for writ remedies, etc., etc. And there were observations which fell from Your Lordships, and I believe that those are answer and those are responses enough in this matter, Your Lordships. The first argument is that writ remedies should not be treated as appropriate courses of action as articulated by the bench itself on day 2 of the hearing, Your Lordships, is that because, first of all, disputed questions of fact will not be adjudicated into. Secondly, the practical limitation which will come about, and Your Lordships know with over 100 years of experience on the bench, Your Lordships, cumulatively, that once this argument is made available to the state, the workers will then be compelled to argue on preliminary objections that whether this is maintainable or not. And even if they move beyond that, Your Lordship, then the queries which will come is that are public functions being performed? Are these public functions not being performed? What is the nature, etc., etc. So these arguments will always deprive the workers of arguing on the core merits of the matter as opposed to the main meat of the matter. Your Lordship, just one last argument in this regard is that what I'm seeking to advance is that the state is coming up with the argument that writ remedies will be an appropriate course of action, and that, in my respectful submission, runs contrary to what is the consistent legislative effort across several years, as recent as this year, Your Lordships, is that this legislature is creating an effort to ensure that more and more specialized tribunals, more and more cases go before these tribunals with expertise, whereas the state is arguing that no, those which are working just fine, please take it away from them. Please come to the high courts. That, in my respectful submission, would add to the already burgeoning judicial docket as opposed to streamlining the issue. And last argument, Your Lordships, and this is a matter of abundant caution because all my colleagues, all my senior colleagues have already flagged this. Your Lordships have indicated during the previous sessions that Your Lordships would consider adding a clarificatory caveat that number one, this operates prospectively, and number two, that the 2020 Act will be adjudicated on its
We have not promised anything, but we are only entertaining the argument.
Yes, Your Lordship. Your Lordship. So my respectful submission is that Your Lordships may lean towards that because the 2020 Act, if Your Lordships were to adjudicate on that, then the possibility of a 9-judge or an 11-judge bench assembling to revisit that is perhaps remote in my respectful submission. So my respectful request would be that Your Lordships may not comment on the 2020 Act and leave all questions of law to be adjudicated at the appropriate time.
Okay, thank you.
And
That's just
really
one
grateful
minute.
for the patience.
I am an individual workman whose services were terminated, my lords, and I have been now reinstated with full back wages. My lords, I'm just reading the bullet points of my note. The first point that I wish to make is there is a clear distinction between sovereign functions and the welfare activities which are performed by the state. Only sovereign functions would qualify for exemption and not the welfare activities. And more specifically, my lords,
Where were
with
you
respect,
working? Where were you working?
my lords, irrigation department of the state of Punjab. I was a baildar. I was doing the work,
What is
manual
your age
labor.
now?
Sorry, my lords.
Age now?
My lords, he has expired, so I've impleted the legal heirs. During the pendency of the case, he expired, my lords.
What is the number?
812 of 2005. 812 of 2005, my lords.
What is the objection raised? That
Well,
it is not
that irrigation department is not an industry, and the labor court and the high court held in my favor. But I could not get the benefit, my lords, because the matter got tagged.
Who is for the state of Punjab?
Mr. Farasat,
What is the number of your case?
812 of 2005,
Take this as LP on.
civil appeal, civil appeal.
Civil appeal number 7. So heard and Mr. Sudan Prasad for on behalf of the state of the leave granted. Heard Mr. Sudan Prasad on behalf of the appellant as well as
Sangeeta Bharti.
on behalf of the legal representatives of the deceased workmen. Keeping the question open as to whether the irrigation department state of Punjab is an industry or not within the meaning of section 2 of the Industrial Dispute Act 1947. However, having regard to the fact that the workman was that the respondent, deceased respondent was engaged in the year.
He was in the year.
The year,
I don't have.
the year so and so year after
The award is of 2002, so my lords.
2002 and after serving for more than
No, he didn't serve for, we fulfilled 240 days, my lords. He was working as a baildar.
and while languishing before one or the other judicial form has unfortunately passed away, leaving behind his legal representatives who have no source of livelihood. We deem it appropriate to invoke our powers under Article 142 of the Constitution and dismiss this appeal.
Just
He was asking
the
for
legal
regularization.
question, we are only on the legal question.
He's asking for regularization.
No,
We are
Mulaz,
against the award. Yes.
he
Continue.
wanted to claim, he wanted to claim
Continuity.
continuity in service as a workman, but since it was not an industry, the irrigation department, Mulaz, that's why we are coming appeal. But we are only on the legal question on the facts, Mulaz. I don't have any difficulty.
Invoke our powers under Article 142 of the Constitution and consequently dismiss this appeal. The legal heirs of the deceased employee shall be entitled to all the consequences.
With lordship may fix a time frame.
Integrity and service.
He was
Is, according to you, he could not have been terminated.
Yes, my lords.
That's right.
He was retrenched under 25F.
Did he work
Only 240 days.
240 days, my lords. We
how many years? 240 days in a year.
last,
How many years did he put in 240
My
days a year?
my lords, I don't have those details.
Station.
My lords, his services were terminated and therefore we asked for continuity of
for
service.
award of reinstatement in service. Because
Yes,
he
ma'am.
had completed 240 days.
He had completed
This
to
was not given. There is a violation of 25F.
F. Yes, my lord.
That's their case. That's their case.
Their objection was only that irrigation department is not an industry.
Plus, he was taken in service in August 395 and termination was July 2097. So just about less than 2 years.
1997. Some luck.
August 395 to 20th July 97.
To all the consequential benefits, including areas of pay, on the premise that the deceased had been reinstated in service and he continued to work till he died. That is state will place is covered.
My lords may just fix a time frame, 4 weeks or 6 weeks,
He
whatever.
died.
Plus death, I'm not sure.
My lord, do you have the
No,
application?
the alerts have not been brought on record.
No, they have been brought on
I'll
record.
just have to check.
They have been brought on.
Yes, Manoj, I'll have to check.
That certificate you mentioned is there. I
It
just
is a
saw it
part of the
somewhere.
record. Don't have the-
I will just point out, I have seen my chart. I remember better than.
Usually when they ask. this
Date of death देखो ना.
Some is.
You have the file.
Plus, we'll give the date. Your lordship need not hold the court for that. We'll give the date.
Of the date.
Yes.
He died just
He
after
died
the
while
award.
it was pending.
While the matter was pending in the Supreme Court, he died, my lords.
Plus 25th of December 2020 is the date of death. 25th December 2020.
So you will get areas.
While the matter was pending in the Supreme Court.
What age?
Age.
40.
I didn't anticipate, my lords.
How much of service you would have had from 97 onwards?
2020. Maybe 15 years more, my lords. Around 20 years of service. 95 to
Plus
97.
23 months was his period of work.
So what should be the
Because I leave that to the court, my lords.
In view of, he cannot be.
It suits me. Just see what date of birth is mentioned anywhere in the record.
Very well, my lords.
We, as guide them say, we are of the
Yeah.
considered opinion that the legal heirs of the deceased, deceased employee are entitled to a lump sum amount of compensation invoking our powers under 142 of the Constitution. From we grant a lump sum amount rupees 10 lakh to the legal representative.
Grateful, my lord.
The amount shall be deposited with the tribunal within 6 weeks. 6 weeks, the tribunal shall identify the LRs of the deceased and will disperse the amount proportionate.
My lords may keep the appeal only for the question of law. Factually, my lords may dispose it. Question of law, that's all. We are also only pressing question of law.
I'm deeply grateful, my lords. Deeply grateful.
Now, so from the now respondent side is over. Mr. Kama, would you like to now start or we allow 10 minutes?
After the amicus concludes, I thought let me come at the end.
Yes, Mr. Kama, please.
Not in the presence of so many eminent counsels, I'm a little apprehensive, but having said that,
I have given a note, Your Lordship, additional submission of 17th of March, Your Lordship. I am appearing in 6 matters, Your Lordship, and the opposite side is Department of Forest, Your Lordship. I am only requesting that Your Lordship may take note of my written submissions, Your Lordship, and the written submissions, actual written submissions are part of volume 2, Your Lordship.
All right, we'll take it.
I may also consider Article 38(2), Article 14, and Article 43A of the Constitution while deciding the issue, Your Lordship. That's all.
What was the relief you sought for regularization?
Your Lordship, yes, Your Lordship, regularization. In 2 cases, it was about pay scales, Your Lordship. There are 6 cases, Your Lordship. So there are different issues, Your Lordship. Please, Your Lordship. In 3 cases, Department of Forest is there. In 1 case, ITI College is there. And in 2 cases, Zilla Parishad is there.
All right, we'll go.
Please, Your Lordship.
no, sir, as I see it, this is an all or nil litigation. The other side says include all. I'm sorry. The other side says include all. And this side says 47 of them say that our individual establishment should not be covered. So this is a peculiar litigation. As I said, it's an all or nil litigation. Now, I want to clarify my position, first of all, as to industry in the hands of government. I think there can be no doubt that industry in the hands of government makes no difference. Industry is industry, but the industry must ultimately come within the element of 2J. It must be a factory, a business, or an undertaking. Now, the other day, my lords had asked, what is the undertaking, whether undertaking would be different or not. The answer to that, my lord, is in three or four passages of the Industrial Disputes Act. First is 2K. 2KA. Can I just take a lordship to that?
Yes.
I'm sorry. 2KA says, industrial establishment or undertaking means an establishment or undertaking in which any industry is carried on. So an undertaking is also an enterprise which is industrial in its nature. It's not separate. Now, if it was separate, there would be a major problem for the workers. If you turn around and see section 25F, 25F is retrenchment. It refers only to the word undertaking. Or double F, I'm sorry, 25 double F. F also. Double F, sorry. Double F is where business is transferred. So undertaking there is obviously relating to industry. It refers to the fact that an undertaking which is of industrial nature is transferred. But the section does not refer to the word industry per se. Similarly, my lord, in 25 triple F, closure, It refers to undertaking. And therefore, undertaking must mean industrial. Now, this position also came up before your Lordship's court in the context of Section 25O. There it referred to an undertaking of an establishment. So this court said an undertaking of an establishment must mean a separate unit of that establishment. An undertaking is it is industry. It's either the whole industry or it's a part of the industry. And it must be read ejustem generis. It must be read in conjunction with the words preceded and subsequent to it. If everything else around it is industry, then surely, my lords, this one word cannot by itself stand out. As a matter of interest, while contemplating workmen, a constitutional bench of this court had to consider whether sales representatives would come within the ambit of workmen. And they said, no, we'll read the entire definition of Section 2S as one section. And having said so, a medical sales representative is neither manual, nor technical, nor clerical, nor supervisory. So they said, we will read all these words together and we'll come to a joint decision. So therefore, in any law, a number of words in one collocation has to have the same meaning. I trust my lord that takes care of that. Give me this is Margaret's judgment. I pointed out that there was a judgment of this court. I'll just hand it across.
It's in volume 6.
Is it not? It's in volume 6 of your lordship's compilation.
What number is it?
What number is it? No, point 1 in volume 6. Malhos have that? Turn kindly also para 16 or 15 rather. 15, 16 and 22.
1986 is this.
15, my lords. 15 will be at page 641. 641.
Volume 6.
Volume 6. Do all my lords have this now? Sorry. It's not. Do all my lords have it now? If you also return to, as I said, para 15 at page 641. It says section 25O. I don't have that. Applies to closure. I'm reading para 15, my lord.
Yes, sir.
Section 25O applies to the closure of an undertaking of an industrial establishment and not to the closure of an industrial establishment. Section 25L, however, defines only the expression industrial establishment and not the expression and undertaking of an industrial establishment. It also does not define the term undertaking. Section 25L does not require that the undertaking of an industrial establishment should also be an industrial establishment or that it should be located in the same premises as the industrial establishment. The term undertaking, though it occurs in several sections of the Industrial Disputes Act, as for example, Section 25 FFA and FFF, is not defined anywhere in the Act. Even a new clause, KA, which was inserted in Section 2 of the amended Act of 1982, defines the expression industrial establishment or undertaking and not the term undertaking simpliciter. It will appear from the opening words of clause KA, namely industrial establishment or undertaking, means an establishment or undertaking in which any industry is carried on. The term undertaking in the definition applies to an industrial undertaking. It would thus appear that the word undertaking, wherever it occurs in Industrial Disputes Act, unless a specific meaning is given to the term by that particular provision, is to be understood in its ordinary meaning and sense. The term undertaking occurring in Section 25 FFF fell for interpretation by this court in Hindustan Steel. In para 10, the court held, the word undertaking as used in Section 25 FFF seems to us to have been used in its ordinary sense, connoting thereby any work, enterprise, project, or business undertaking. It is not intended to cover the entire industry or business of the employer, as was suggested on behalf of the respondent. Even closure of a stoppage of part of the business or activities of the employer would seem in law to be covered by this subsection. The question has indeed to be decided on the facts of each case. Para 16. It is thus clear that the word undertaking in the expression an undertaking for an industrial establishment in section 25O means an undertaking in its ordinary meaning and sense as defined in the court in Hindustan Steel. If an undertaking in its ordinary meaning and sense is a part of the industrial establishment, so that both taken together constitute one establishment, section 25O would apply to the closure of the undertaking, provided the conditions laid down in 25K were satisfied. Now, this was a case where the doctrine of functional integrality was involved. The question was whether the factory and the head office should be linked together. Was it a separate undertaking? And the court said no, because the factory could not survive without the head office. So therefore, it was considered to be one undertaking. The undertaking means industrial. And it appears in the collocation of words in 2J. So therefore, it must be given that meaning. It can't be given a totally independent meaning. Now, my lords, coming to the rival situation, I'm sorry, can I just take your lordship very briefly into the Act? Because when you interpret a section, you have to look at the Act. What is it? All right, here it is. Now, the Act, certain sections of the Act are relevant for your lordship's consideration. First, my lords, is section 2K. Do all my lords have 2K? Industry, as my lords have heard by now, means a business undertaking, trade undertaking, manufacturing or calling employees, and includes any calling, service, employment, handicraft, industrial occupation or avocation. I want your lordships to understand that this definition is in two parts. It is not just one continuous definition. In the context of an employer, it means business, trade, undertaking, manufacture or calling of employers, and includes any calling, service, employment, handicraft, or industrial occupation or avocation of workmen. So there are two separate parts of the same definition. This is relevant because in Banerjee's case, this court concluded that the length and strength of the definition was reinforced by the second part. The second part, therefore, has no part to play in the first part. Now, if you turn to the word industrial dispute, that is section 2K. Do my lords have 2K? 2K says industrial dispute means any dispute or difference between employer and employers, or between employers and workmen, or between workmen and workmen, which is connected with the employment or non-employment or terms of employment or with the conditions of labor. So it is a dispute between employers and employers, employers and workmen, or between workmen and workmen. So industrial dispute comes, I mean, that is how you read section 2J industry. Industry means a dispute between workmen and workmen as much as it means a dispute between workmen and the employer. So that must be clearly understood. Now we come down to the question as to whether all and every employment is an industry. My learned friends on this side would like to say that everything is included in industry, including a charitable organization. I agree with them, except for the word charity. As far as charity is concerned, pure and simple charity, government supplying milk to work people, government giving free education, that is not industry. But short of that, anything where there is a employer and employee engage in an activity which involves an industry would be covered. So I'm on with my learned friends in totality on the question of coverage. To mine, therefore, it is not what, it is the who of the matter. The who of the matter is not relevant, it is the what of the matter. Who can be anybody, whether it's the government or otherwise. Now, the only question will arise in the case of regal functions, whether regal functions could be covered by this aspect. I would submit that if regal functions can be divided into industrial and pure regal, it is possible for the court to take the view that the purely industrial as opposed from the purely regal functions are included. It is interesting to know that today, even in defense, you have the Armed Forces Act. So even though that's a strictly regal function of the government, still people are able to go to court. So therefore, regal by itself, to my mind, may not be a complete ouster. If there is an element in the regal function which involves an employer-employee relationship, then it is possible to conclude that even that is included within the concept of Industrial Disputes Act. However, in the case of defense, since the Armed Forces Act is there, the Industrial Disputes Act will not be drawn in. But I'm just drawing an analogy.
I get the feeling that Jamshedji.
Now, if you turn back to 25K(A) for a moment. So, sorry, 2K(A), my apologies.
Why do you say that if free education is provided by the government, then it has to be excluded from the definition?
Because, my lords, the concept of charity and the concept of industry are basically antithetical. Pure charity is not industry, it can't be industry.
Structure is the same.
Structure may be the same. As I said, structure is not
Whether it's a
relevant for-
private school or a government school.
It is the object of the action. If the object is not to benefit the government or to benefit a department of the government, if I'm not charging fees, then it's not an industry by its very word. To my mind, there has to be, there's something more than charity in an industry. Now, I have an issue with Justice Krishna's triple test also. I'll come to that because ultimately that was a question my lords have raised before us. And apart from one or two of our learned friends, nobody has really addressed that. I'll come to that in a moment.
For education purposes, now there is Education Act of the states. They go to the Education Tribunal.
No,
They have a separate tribunal.
no, that is all, but they won't come under ID Act. That's my submission. Because to my mind, it is antithetical to industry.
Mr. Kama, so your argument, if I've correctly understood, is to enlarge the restrictive import of paragraphs 109 and 110 of Justice Iyer's judgment. The three categories, A, B, and C.
I will restrict it. I will not enlarge it. When I come to it,
You will restrict it first.
I will restrict it.
And that's what
I'm sorry.
I'm saying.
Yes.
That Justice Iyer says only clause C would be carved out of the definition of industry. You would include perhaps B.
Yes.
As a charitable object.
But a pure charity, as I said, I'm defining a pure charity from a charity where you charge money. Now, where you charge money, there is, to my mind, an industrial element. But where you don't charge a pie and you do it in...
If I can clarify on, clause A says it's an institution which is run on business lines, but plows back the surplus into altruistic activity. Would you define that as?
Well, I would take that as out of the act. Because whether the action is done directly by the government or it is done by plowing back. But if the plowing back in the form of fees, or if the plowing back is in the form of a revenue return, then it is an industry. But if it is plowed back on its own without taking it as income, to my mind here the test would be income. I don't know how your lordship's illustration would. How do you plow back? If you have a pure charity, the question which comes to my mind is how does one have a plowback?
I'm just using the words in paragraph 109, where Justice Iyer says that the surplus is used for altruistic purposes.
So, your lordship are talking about industry and there is a surplus. And a surplus is used for altruistic purposes.
So that will not be.
No, that to the extent.
That would definitely be an industry and not a charitable.
To the extent it is like we do dominant theory, we'd have to apply the dominant nature theory. If the dominant nature of the work is industrial, the fact that you plow back a little bit into charity won't make it.
Then you are proposing that paragraph 185 of Justice Jaswant Singh's is a better interpretation of.
I would think, my lord, so. I would think so, but then there's one difficulty there. There's commercial requirement. Here, I'm not insisting on a commercial requirement.
Right.
I'm only saying if you are paying somebody something, it may be purely altruistic, but you are paying a workman to work for you in that altruistic activity, and by that altruistic activity, you are earning a revenue. Then the revenue which you earn is part of industry. Now, if you, to my mind, if you just pay somebody to do altruistic work, and that altruistic work is pure and simple altruistic without any commercial or other sense, then it is not industry. That's my point. Now let's go. coming down to what my learned friends had argued, I'm sorry, I was showing lordships 2KA, as my learned friend points out. Go back to that kindly. Just to show you lordships now that not everything is an industry. Not everything is an industry. The moment one speaks of dominant purpose, one realizes that there is something which is not an industry and something which is an industry. So,
Validity test has to be applied.
so therefore, my lords, clearly not everything in this country is an industry. Where I find fault with Justice Ayer's 4 principles or 3 principles is that he insists that it has to be a management and employer relationship which brings about industry. I don't agree. And I'll tell you, lordships, why I would recommend that your lordships also do not agree. Because in any employment, even if it is purely altruistic, there might be a employer-employee relationship. So employer-employee relationship or master and servant relationship cannot be the test. The test has to be twofold. Actually, the act is very simple. We have made it difficult. The test is simply this: is it industry in the sense of those 4 or 5 words used on top? If those 4 or 5 words are there, next question is the person employed there a workman? Now, a workman is not anybody. He's manual, technical, clerical, supervisory. Now, if you look at that category, you have to consider whether he is working, or he comes within that. Now, for example, a supervisor over 15,000 is not a workman. Or if you have an industry where only sales representatives are there, they're not workmen under a division, constitution and judgment. In that case, even if the industry on top is business, it has to be business dealing with workmen. And correspondingly, even if you are a workman, you must have an industry. The two are coterminous. So therefore, when you look at section 25J, 2J, if you look at 2J, there are 2 parts of 2J on the top itself, separating it from workmen's industries. And there is also the necessity to consider whether the persons engaged in that industry are workmen.
Sir, you say the word any employment of workmen, where the emphasis in the second part of the definition is on the relationship between the employer and the employee.
That's right.
It's colored by the nature of the undertaking in which the employment operates.
It goes both ways. If the undertaking is not a business, then the fact that he's a workman will not make it an industry. Correspondingly, if it is an industry in the sense of section 2I, but the persons employed by them are not workmen.
So you say the word "and" has to be read conjunctive.
No, I'm not on the word "and." I'm on the simple thing that industrial dispute as defined is a dispute between management and labor. Now, when you talk of management and labor, you obviously speak about management as defined and you speak of labor as defined. If either of those 2 elements is not there, it's not an industry. It's not an industrial dispute.
So section 2J and 2S must coalesce.
That's right. That's right. Then only will it be an industry. And I'm emphasizing this because Justice Ayer's 3-point test, and I'll come to it in a moment, I don't agree with it because he's relying only on employer-employee relationships. And that is in every industry.
Mr. Kama, you are reading undertaking as a business undertaking?
Yes.
And look here, undertaking, as far as my knowledge of English goes, has different shades of meaning. One undertaking could be establishment, enterprise. The second would be what we write in our orders. Somebody gives an undertaking that he would comply. That is promise. Having regard to the previous and the subsequent words of 2J, why shouldn't undertaking be read as a venture?
Because your lordships are aware of the fact that when you read 4 or 5 words in one definition, they must have the same meaning. You can't have industry defined as manufacturing and undertaking is something totally different.
Undertaking could be said in this sense, I have undertaken this work. In that sense also, it is undertaking.
But I'm supported in my submission by reference to 25FF. Now, if that was correct, then there can be no application for transfer. There can be no application for closure. If undertaking is not industry itself, then under 25FF, who is being transferred? Who is doing the transfer? Who is doing the closure?
Purpose of 25FF and FFF, you have to borrow the meaning from KA. 2KA.
It's part of it. But that's also in the undertaking, an undertaking in any industry.
So it, industrial establishment or undertaking, do we read only industrial establishment and undertaking separately, or industrial has to be read before undertaking also?
The second line says that. The second line
It's
into
an establishment or undertaking,
in an industry.
right? In which any
So it
industry
has to be in an industry.
has to be, because otherwise the word industrial would not have come
That's
before
right.
establishment.
That's right. So I'm saying, look at the entire act. If you see the entire act, the undertaking can't be anything different from what comes before and what comes after. It would otherwise be a peculiar interpretation to say that in the definition clause, these two words are covered by the definition. This one word is not, and the next two words are.
But they didn't apply the Nosita SO side.
They should have to apply that.
They didn't apply it.
They didn't.
They didn't apply it. For example, BSNL, which deals with telephones, etc. Is that an undertaking, or is it trade, business, manufacture, or calling of employers?
It is an
It's
undertaking.
an undertaking.
It's an undertaking.
Even though there is no manufacturing.
That's right. An undertaking can be the whole establishment or it can be a part of an establishment. It can be the whole industry. Now, for example, in 25FF, as I mentioned, it deals with the whole industry. In 25O, it deals with a part of the industry. So undertaking is industry, whether whole or part.
Manufacturing is not one of the compulsory or mandatory essential of an industry.
I'm sorry?
Manufacturing.
It can be in trade also.
Yes.
I mean, calling, either of them. Any of the top line. Now, therefore, once we have understood that an industry and workmen have to read together, and once we have understood that not every employment is an industry, we have to then test what is meant by industry. Now, industry has to have a common sense meaning. The legislature does not legislate with an Oxfordian purpose. It legislates common understanding. Now, when you say trade or business or manufacturing, what did the legislature mean? It had to mean industry must mean these things. It must be. There's no other meaning to the word industry. Let us read the word industry together. Industry is a business, trade, undertaking, manufacture, or calling. Now, in order for it to be an industry, it has to be one of these. What Justice Iyer does, he says, I'm not concerned with whether or not it's an industry. I am saying that any and every person who engages in a relationship with an employer is industry.
It's too wide according to
Far too wide. Far too wide. Now, in this context, let's go back to Justice Iyer's judgment and have a look at that. It's at paragraph 140 of the judgment.
It's not necessary. Trade, business, manufacturing. Nevertheless, it's an undertaking.
Fine, judgment is here. Do my lords have that, Justice Iyer's judgment in hand? It is, my lords, in volume 5.35. No, 140.
140. Yes.
It's not trade, business, but it's not undertaking.
No, page 2147 in the volume. I don't know on the computer otherwise.
It's 5B.
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 It's in volume 5.35.
It's in both.
So which paragraph of Bangalore?
140.
140.
This is my copy of the act. In judgment. Anyway, it doesn't matter. My lords have 140. Let's read together, my lord. I mean, I'm sure your lordships are tired of reading this by now, but let's read it together one more time. Industry as defined in section 2F and J and explained in Banerjee has a wide import. Where systemic activity organized by a cooperation between employer and employees, the direct and substantive element is chimeral for the production and distribution of goods and services calculated to satisfy human wants and wishes, but inclusive of material things or services geared to celestial bliss, example, making on a large scale prasada food. prima facie the industry. Now, absence of profit motive or gainful objective is irrelevant. I don't agree. How can there be a trade or a business which doesn't have a profit motive? It may be that a government may reduce the profits to itself, but so long as it wants to run an industry, industry by its very nature has to be profit oriented. Now, therefore, the first sub-clause, absence of profit motive or gainful objective irrelevant for the venture in the public joint. I take issue with this. There cannot be a trade. You see, you have to look at the definition as it stands, not as you seek to interpret it. The definition as it stands is business trade. Business trade cannot be without a profit motive. Then the next paragraph, the true focus is functional and the decisive test is the nature of the activity with special emphasis on the employer-employee relationship. If the organization is a trade or business, it does not cease to be one because of philanthropy animating the undertaking. Now let's go one by one. One, A and B I've dealt with. C, the true focus is functional and the decisive test is the nature of activity of the with special emphasis on the employee. Now this is what you will find in the three overruled judgments. In solicitor's case, in Madras Gymkhana's case, in all of them, the common trend was that there is an employer-employee relationship and therefore it is an industry. What the learned judges have failed to notice is that you have to be a trade. Now, therefore, a club, let's analyze it. Can a club be called a business? Can it be called manufacturing? Can it be called any of the other four items in that? If it can, then employer-employee relationship must be there. But employer-employee relationship will be there even if it is not that. In any industry of any, I'm using the word industry, in any human activity, there has to be employer-employee relationship. So the employer-employee relationship is not a crucial issue. The crucial issue is whether it falls under that definition on top.
Employer-employee is a means of conducting is according to you.
Yes.
Employer-employees are perhaps the means of conducting.
Yes.
That's not the definition part of it.
You see, the learned judges here have gone beyond the statutory words. Perhaps in the socio-economic intention of the judges, they wanted to spread the word, as they say, spread the butter. But the point in doing so, they have done something which has gone contrary to the statute that they were interpreting. It must be remembered that the Industrial Disputes Act is not only meant for workmen. It is also meant for managements. Today, if an industrial dispute is raised and an award goes against management, it can be in multiple crores. And I find that very often your lordships, both at the High Court and here, are overly generous. No, pay the man something. So therefore, if I am to suffer that, then I must be covered. I can't suffer that. I don't want to suffer that if I'm not covered. It's an either or situation. So am I in industry as defined in 2J? Am I employing workmen as employed, as mentioned in 2S? And I'm in industry and I must suffer the consequences. But if I am not, then I don't want to suffer the consequences. So therefore, one has to define the word 2J as it stands.
Mr. Kama, you've been repeatedly being addressed on what is the object of this entire legislation. But if you come to the preamble, it says settlement of industrial disputes.
Yes.
So essentially, it's neither pro-workman nor pro-employer.
Both.
It is pro-peace.
Yes.
The industrial dispute
Yes.
is in the heart of this legislation.
Right.
And its settlement is its core. So if we don't take an expansionist definition of industry, we leave out various human activities where interface of employer-employee comes in. Out of this ameliorative law relating to industrial peace.
Look at the difficulty in this. Turn to Justice Iyer's observation at page 283. Just look at that. That's exactly what happens. Page 283. Let's say para 141 first. Do all my lords have 141? Although section 2J uses words of the widest amplitude, in its two limbs, this meaning cannot be magnified to overreach itself. That's what I'm saying. Right? Now,
That is where Justice Chandrachud, in fact, uses the most articulate expression that we have this sticky problem.
Yes.
Where do we draw the line through judicial pronouncement? It is best left to the legislature.
Now, in the context, I mean, everybody has a soft spot for labor. So do I. But when you have, yes. Your sarcasm doesn't do you credit. But then don't be sarcastic to me. It doesn't do me good. Leave it. The point I'm making, I lost my train of thought.
We've been traditional opponents. It was just an aside. I'm sorry.
No, Madam Indra, please don't make any this kind of comments. He is not here because of that representation.
Yes.
Breaks the continuity, madam.
Now, can you go back to 140?
The way he is building up his argument, that gets disconnected.
I'm very sorry.
And then you wouldn't expect it to happen when you are arguing.
Just to help Mr. Kama, I think Justice Bagchi's question to you, which you are responding to, about drawing a line and.
For that, you went to para 141.
Now, 141, the learned judges, I'm deeply obliged. I think my age is catching up with me. 141, can you read that again, my lords, if you don't mind? It says, although section 2J uses words in the widest amplitude in its two limbs, this meaning cannot be magnified to overreach itself. And that's the point I'm making. Now, having said that, look at the next paragraph. The next paragraph says, undertaking must suffer a contextual and associational shrinkage, as explained in Banerjee. And in this judgment, so also service calling and like. This yields the inference that all organized activities possessing the triple element, although not trade or business, may still be industry. This is what happens when you magnify the language. The learned judges themselves say, don't magnify it. And then he says, even if it's not an industry, we're still covered. Therefore, if I was to address your lordships on this question, as I am trying to do now, my submission would be Justice Iyer's judgment has gone too far.
But it says, but resembles to what we find in trade or business.
Yes.
So is in fact applying the nocitor associs here.
But when he says it need not be a business, what does that mean? Nocitor associs would mean that all those are in
resemblance to what we find in trade or business.
No, but then he says, they still provided the nature of active, although not trade or business.
Sir, we would, in all probability, Justice Iyer meant was even if we take out the profit element from trade or business, the character of a trade or business being a systemic, organized activity to create goods or services of value
Yes.
is what is the essence we will find in the definition.
Absolutely. But in interpreting business and trade, employer-employee relationship is not the crux. That's the point I'm making.
It's
undoubtedly.
complemental.
It is
complemental.
Sorry, it's complementary.
It's complemental because the activity must express itself in an interface between
undoubtedly
capital and labor in the form of an employer-employee relation.
Undoubtedly, but look what Justice Iyer says in clause C under 140. The true focus is functional and decisive. The test is in nature of activity with special emphasis on employer-employee relations. He has, in all the judgments that he has overruled, the learned judge has gone on this basis. He says, solicitors, you have staff assisting you. In a club, you have employees working for you. That's not the test. Can one really say that a club is a manufacturing entity? Can we say that? You see, ultimately, in interpretation, we have to also use common sense. You have to use common understanding of a particular word. Now, industry has been given 4 or 5 subcategories. You have to read them in the understanding of people. When Parliament enacted it, Parliament does not consist of great forensic experts. They defined it in the manner in which a common man defines it. So therefore, when you say business, trade, or other thing, you have to look at that. Now, emphasis on management and labor with a view to overturn the definition is wrong. You can't say, I will say that it is a trade because there are workmen and management. It is that because which is bothering me. So therefore,
means despite there being workmen, it need not be an industry.
That's right. That's right. So therefore, those categories which are given, they are categories which are the fundamentals for interpretation. Now here, the learned judges have put the tail before the horse, whatever it is. The point remains, cart before the horse. I'm sorry.
Rather, it is tail wagging the dog.
Yes, I thought of that also.
According to
Yeah. Now, therefore,
In case of clubs, doctrine of mutuality in fact applies.
yes, absolutely. And this members for members. A club is by members for members.
Technically, there are workmen.
Even in a cooperative society, it's by members for members. Therefore, you can't say that a cooperative society would be an industry just because it employs labor.
They have their own act, cooperative society.
I'm only emphasizing for my lords one more time that the test of Justice Iyer is based on master and servant, and that is the wrong test. The test should be, and I'll tell my lord what the test should be.
what should be the test?
The test should be whether it is business, trade, etc. First, employing labor as defined in Section 2S, straightforward. You don't need complicated constructions. Is it a business, trade, or whatever else, as understood in common parlance? And does it employ workmen? That should be the only test.
The thing is undertaking, there again, whether it should take color from business, trade,
It does.
manufacture, or it should not.
It does. As I pointed out to Lordship, it does. It is undertaking in an industry. So it takes its color from it.
Mr. Kama, you should also, sorry, sister. To also go a little step further in also explaining the essence of business, trade, or man.
Yes.
You need to find something more in that, to find some kind of a commonality.
No, that I will leave it to your
I
Lordship.
completely agree that it is perhaps not in the binary of employer-employee.
That's right.
It's not in that binary which will define a, industry. But what would define industry would be on the basis of how you find the essence of these
Manoj,
expressions.
if we take,
One is a systematic activity.
yes, I agree with that.
Something.
I agree with that. No question. But what is meant by business? We don't need to look at a dictionary for that. It's understood. So therefore, and I'm repeating myself when I say that parliamentarians are not the most educated. When they therefore used a word, they use it in the common parlance. And in common parlance, what does business mean? They use the Hindi word danda. When I just finished in the afternoon.
Kama, you go ahead the way you want. You explain your opinion on triple test.
Yes.
And then as the question will come, then what should be according to you, what is the real true important meaning of the
the definition
entire
of industrial dispute.
Absolutely.
Well, I'm very clear in my mind. Test the court, whichever is dealing with it, must test whether it comes within the 4 or 5 categories. Then it must test whether the person who is claiming to be employed therein is a workman within the meaning of the act. Full stop. Why should we go more complicated? That was the intention of the act. Industry as defined, workman as defined. It should be as simple as that.
But Mr. Kama, if you put it in that narrow encapsulated form, then the entire governmental activity will be hived out of industry because government does not operate for profit.
Government today is the largest industrialist. Today, government has entered the field of industry in a massive manner. But I'll tell you something. If it is not covered, it is not covered. Let us look at the definition.
Contextual understanding of appropriate government and other provisions of the industrial field.
If I may put it this way, if the government is carrying on business, then because it's the government makes no difference. But if it's a government and is not carrying on business, then just because it is an employer of sorts doesn't make it an industry. It has to be carrying on a business, and government does.
We continue after. Yes, Nils.
Before lunch, my Lord Justice Bhakti asked me a question about government. I've been giving it some thought just now over lunch, and I have an answer which is complete. Turn to section 2G. Where is 2G? I'll read it to your Lordship's 2G. It says, employer in relations to an industry carried on by or under the authority of the Department of Central Government or a state government shall be the authority prescribed. So in case of government, it is relation, is an industry. It applies only where there's an industry. Now also, my Lords will notice that the kinds of industries are further restricted by section 2A. Section 2A specifies the kind of industries to which the ID Act will apply. So therefore, there is a restricted element on industry. First, 2A, only those industries can be referred because appropriate government, it says for appropriate government in central case, it is these, and for others, it is the state. Now, the appropriate government, therefore, is a government which has to make the reference. And no reference can be made otherwise than what is mentioned in 2A and 2B for state. So therefore, there is inherently in the Act a restriction. Not every employment comes within the contemplation of section 2J. Now, if you look at 2J again, it says means. It is therefore, your Lordship have always said when a definition clause says means, then means, nothing more than that. It has to be read strictly. See section 2J. And then it says includes the employee's definition. So 2J is express. Nothing else but that. Now, let us test Justice Ayer's judgment again there. Can your Lordships really say that a club is a business, trade, or undertaking or manufacturing? It is a social organization by members for their own purposes and for their own pleasure. It's not an industry. If you give industry the common parlance and common understanding it meant, again, take a research institution. Can you really say the research institution is a trade, undertaking, manufacturer? So you have to come within that. And in my respectful submission, you have to look at the definition as it stands and not with additions. You don't look at the definition by saying that because the government has funded it, therefore it is an industry, or because nobody has funded it, therefore it is not an industry. Is it as it stands, is it a trade? Is it a business? If it is, then whether it's funded by A, B, or C, or whether it's not funded by A, B, or C, makes no difference. It is simple, it is as clear. The idea really, as I have studied it today for this matter, is absolutely clear in its intent. It says who is covered, which workmen are to be considered for this purpose, and then it tells you, Lordship, how to understand it. Now, what has happened today is that because of these judgments, we have gone behind the words. We have gone behind the words to find something which will allow us to have a social welfare aspect. Now, my lords, I have no difficulty with social welfare. It's a good thing. But social welfare must end where the definition is clear. There can be no social welfare legislation contrary to the strict language of the Act. And where the language, like in this case, is specific and clear, then you can't have social welfare. You can't take a club and put it into industry. You can't take a research institute and put it into manufacturing. So therefore, this endeavor of the court earlier to try and find some method, some means to extend the Act is with great respect not permissible, nor was it required. Social welfare must stop where the statute is clear.
Justice Iyer himself said nothing more and nothing less.
That's right.
He himself said.
Yes, he says can't expand it, and then he goes on to say even if not an industry, still covered. In 142, he says that, and then the next paragraph he says even if it's not an industry, still uncovered. And that is what has happened. Because of this expensive interpretation, we've had a problem. Now, let's, there is this answers, if I hope the first question. Now, as far as the second question is concerned, I have prepared a list of what constitutes sovereign functions from the various judgments that we had. I'll just hand it across. 9 copies. I'm sorry, before I go to that, there is a judgment, I'm sorry, just 1 second. Adhyantaya. In HR Adhyantaya, a constitution bench of this court had occasion to consider whether the definition of section 2S, workman, was specific or was it to be considered as ejusdem generis? And the court said there was a new word introduced. And the court said you will read all the words in the statute ejusdem generis. The word was operational. Now, the matter related to sales representatives. So the question asked is why can't sales representatives be considered to be operational? The argument made was it is not manual, technical, clerical. Therefore, it can't fall within operational because operational has to be read coterminously with the other words. And that's what the court has held. Do my lords have the judgment? Turn kindly to page 755.
Business person from the public. Any person shown to service. And that was proceeding on the include was any such person will be different. This doesn't that it's in because of this expression engaged in employed in because pardon so that
So my lords, I will refer this HR.
yes.
Adhyantaya.
1994 4 SCC.
Adhyantaya.
Now, do all my lords have it? Now, turn my lords to page 755. Bear in mind that here the case was the new word operational. 755. From the top, please leave about 6 lines as regards. My lords have it. As regards the word skilled, we are of the view that the connotations of the said word in the context in which it is used will not include the work of a sales promotion employee, such as the medical representative in the present case. The word has to be considered ejusdem generis, and thus that's construed would mean skilled work, whether manual or non-manual, which is of a genre of the other types of which of a genre of the other types of work mentioned in the definition. Therefore, if in interpreting the word workman, this court has held that you have to read all the words ejusdem generis or nasara sasit, then there's no reason why we should not do the same thing in the case of employer. So even in the industry definition, it's the flip side. Workman is one side and the other side is employer. So therefore, if you read workman as ejusdem generis, you must also read the employer as ejusdem generis. And to my mind, quite frankly, there's no reason not to. Now, notes what I was mentioning earlier. That is my copy. Plastic folder.
Definition.
No.
This is yours? This
Well, it's, I've given your lordship in context of the second question. Maybe just read it together. The second issue my lords had raised, let us just read it together. It says, whether social welfare activities and schemes or other enterprises undertaken by the government departments or their instrumentalities can be construed as an industrial activity for the purposes of section 2J. Once again, like in charity, I would submit that if there's a social welfare activity, if the intention is to make money out of it and then pay the people concerned, it would be an industry. But if social welfare is done, as I said, feeding the poor, giving housing to poor, if it is done altruistically and without any element of financial intention or profit, even my lords, if it is floated out.
The idea, Mr. Kama, the idea of profit is more economics than it is of law. Until the idea of what is profit is more in the balance of an economic term than a legal term. And profit at best may be defined under the income tax. But when it comes to what is altruism and what is charity, and in relation to an organized activity creating value, where do you make the distinction between value being created of goods on a temporal basis or in respect of a temporal perspective and the utilization of such goods and services for creating surplus or value?
I have a bottom line.
Let us say someone manufactures food and distributes it free. It is, as in the majority view of Justice Iyer, it is charity in relation to the consumer of food, but it is not in relation to the workmen who manufacture the food who are paid a salary for it.
But if they're paid a salary for it, then perhaps we can consider, I'm not saying yes or no.
That is the distinction between groups B and group C. A non-profit organization which creates value and distributes valuable goods and services without remuneration, without a price attached to it, but the relation of labor and the employer, that's the employee and the employer, is on trade or commercial terms. That is, you get a salary for it. So why should we make that distinction?
I'll tell my lords why. Because your lordships are not reading the word manufacture and the other three words. You have to come within that. Then you can say, hey, this is an industry. Now you can have government running.
So we are reading the word. The second part of the definition includes any employment, and the word is any. Why should we restrict an employment only for profit motive?
You also are reading the definition of industry.
Yes. In the definition of.
My lords, but the other part applies to industrial disputes raised by workmen. We are not concerned with that. That is why I pointed out that the section is in two parts. That is the whole. In Banerjee, they made this mistake. They said that the definition is expansive because it includes these words also. The definition is not expansive. Definition is simple. One part is for industrial disputes by managements, and the other part is for industrial disputes by workmen. And that is why.
There are two hands clapping.
No, there are two hands clapping independently. You see now, for example, workmen may also have a dispute. You have a cooperative canteen in some companies run by workmen. Dispute arises. There you are. That's the second part. I know a case when Kamani's, for example, the company was taken over by the workmen.
You may say that there would be an industrial dispute in a charitable organization between two groups
of
workmen, but there may not be an industrial dispute between the employer and.
Absolutely. Absolutely, madam. I'm deeply grateful.
Will that not, Mr. Kama,
No,
be
madam.
a very restricted?
If you take it as separate, that's why I'm saying in Banerjee, they made this mistake. They say the definition is expanded because of this. It is not expanded. It means this and includes that. Now, madam, therefore, what I would submit that a charitable organization cannot come within trade, cannot come within business. It is by its very language antithetical. So therefore, my submission to your lordships is that even if somebody is doing some work for a salary, is the work itself an industry? You see now, if I may clarify my position here, when you say that the work industry must mean undertaking, manufacture or calling, it must be an industry, must be manufacture or calling or whatever it is in itself intrinsically. It does not become a manufacturer and calling because somebody works in it. You may have an establishment which is not an industry as defined here and still has somebody working in it. What I'm at pains to point out is that when you look at this, you must first see, is it a trade? Is it a business? And then look to see whether there's anybody employed or not employed. Because then that person is not, the tail does not wag the dog. The dog is industry on top, trade, business, manufacturing. That is the dog.
Then all municipal corporations, educational institutions, forget about the aspect of charity, will be out. If the definition, as you say, is to be applied. Municipal corporations, educational institutions, because they cannot take color from the words business, trade, manufacture.
Then I would say that they are out. You can't be overawed by what's happening outside the definition. One has to read the definition as it stands. If the parliament wanted that that should be covered, then like in the latest act, they would have included it. But so long as the latest act does not cover the subject we are dealing with, if it is not an industry, it is not an industry. I must say that we must have the courage to say it is not an industry. Why? Because it doesn't come within those parameters. We have been going out of our way to find grounds and reasons to explain away the word in the section. Why? Why do we do that? Social welfare is all very well. There's a judgment, I don't have it in my hand just now, but I'll have it later to your lordships, where your lordships have held that even in social welfare legislation, the social welfare element will give way to the precise language of the statute. Now, is there any doubt as to the meaning of the words in section 2J? Business, manufacture, etc. There's no dispute as to what it is. Now, therefore, if it falls within that, then whether it is with workman's hand or not with workman's hand, profit or no profit, it will not be relevant. It will be an industry. But if it does not fall within the definition of trade, business, etc., then no matter what the consequences, it is not a trade.
That means you're applying the Nausica's office test.
Absolutely.
They
And
didn't do it in
I beg your pardon?
Bangalore water supply matter, they didn't apply it.
I'm sorry, I can't hear that.
The Bangalore water supply case,
Yes,
this court did not apply the test.
that's right. They refuse to apply it. Rejected. So therefore, Manoj, what I'm submitting is that don't get overawed by the consequences of your interpretation. Interpretation is interpretation. If the legislature wants to improve upon it, the legislature will do so. But until that time, we are bound to follow the law as it stands and not make up additional grounds.
Because there are some cases concerning social forestry, whether it is an undertaking or not.
If it is purely charitable, it is not. But if it is done by by the department as an industrial activity, maybe for the welfare of its own people, it is an industry. Please, Manoj, bear in mind that charity is antithetical to industry. You may have a charitable organization, but it will not be an industry because it is not involved in manufacture, trade, or any of the other words. Please, therefore, confine 2J to the language as it stands. And the mere fact that it's a social welfare legislation should not persuade this court to go beyond the language of the statute. I know that in social welfare legislation, we have a more liberal approach. One must look to see whether this section allows for liberal approach. To my submission, it doesn't. Please bear in mind, as I said just now, that 2J starts with the word means. Now, your lordships have always laid down the difference between means and includes. If it means, it means. That's it.
It's exhaustive.
Exhaustive. And that is what this section is. It's exhaustive. Now, having said that and taken enough of your lordship's time on that subject, let me take you to the second and third questions. Yes. Now, Manoj, my note before your lordships, have you given it there? Yeah. I have submitted a note and marked it issue number 3.
Yes, we have the note, Scott. We got the note.
Lordship has it. Now, the question on question 3, if your lordships have asked, is what state activities will be covered by the expression sovereign functions and whether such activities fall within or outside the purview of section 2J. This is a note based on what I have culled out from the various judgments which have been cited. A sovereign function usually defined as an essentially inalienable act performed exclusively by states such as defense, diplomacy, and lawmaking. These functions are core, non-negotiable duties aimed at preserving the state's security and peace and territorial integrity. The term has been defined in several judgments of the Honorable Court as under. In Corporation of Nagpur, the court defined this phrase as under such regal functions shall be confined to legislative power, administration, law, and judicial power. Bangalore Water Supply said what is meant by the use of the term sovereign in relation to activities of the state is more accurately brought out by using the term governmental functions, though there are difficulties here also inasmuch as the government has entered largely the new field of industry. Therefore, only those services which are governed by separate rules and constitutional provisions, such as Article 310 and 311, should, strictly speaking, be excluded from the sphere of industry by necessary implication. Further, it is held at page 296 for Chandrachud CJ that one of the exceptions carved out by the court is in favor of activities undertaken by the government in the exercise of its inalienable functions and under the Constitution, call it regal, sovereign, or any other name. I see a justification for accepting these categories of public utility services from the definition of industry. In Chief Conservator of Forests held that the sovereign functions strictly understood alone qualify for exception and not the welfare activities or economic adventures undertaken by the government or statutory bodies. Held that even in departments discharging sovereign functions, if there are units which are industries and they are substantially severable, they can be considered to come within the concept of industry. Held at page 300, that old and archaic concept of sovereignty does not survive as sovereignty now vests in the public. At para 12, the test of sovereign functions is to find out whether the state is answerable for such actions in courts of law. Several kinds of sovereign functions were set out in para 12. They are not amenable to jurisdiction of civil courts, as the state is immune to be sued in such matters in a civil court. It was held at para 13 that the court cannot extend the concept of sovereign functions to include all welfare activities. Otherwise, the ratio in Bangalore water supply and sewerage board would be reduced substantially. In Agricultural Produce Market Committee versus Ashok so it was held that sovereign functions mean defense of the country, raising armed forces, making peace or war, foreign affairs, power to acquire and retain territory. These are not amenable to the jurisdiction of the ordinary civil courts. It was further held that if one is merely an employee of a statutory body, his employment will not be outside the ID Act. Lastly, if we have to find whether it is an industry or not, it is necessary to determine its pith and substance. Further, para 80, the court concluded that sovereign functions in the new sense may have very wide ramifications. Not all functions of the state can be referred to as primary and inalienable functions. Several examples have been given of sovereign functions. Therefore, for determining whether a particular function is sovereign or not, it is necessary to find out which of the functions of the state could be undertaken by any private person or body. Such functions cannot be called sovereign functions. It is clear that from the above that the sovereign functions per se would be outside the industrial dispute act, but social welfare activities would be covered. So now, a sovereign function, to the extent it is only a sovereign function, is immune from civil courts. But if there is an element of industry within that, then the ID Act, to that extent, will be applicable. This also answers the second question on social welfare. I think I've answered the questions raised by you, and I'm very grateful for a very patient hearing from all your lordships. Thank you.
Thank you, Mr. Kama. Thank you. Thank you.
Mr. Kama, about the lack of forum, what is your submission on that?
Lack of forum. Now, let's take a supervisor earning over 50,000. Where is his forum? There is no forum. Take a white collar worker. Section 14 will prevent him from going to any civil court. You see, if the law wants to give you a forum, it gives you. But just because you don't have a forum doesn't mean you alter the law. Now, as I said to you earlier, a supervisor working next to me, earning over 15,000, he has no remedy. A white collar a white collar employee who's sitting in the desk next to mine, supervising my work, no remedy. So where the law wants to give you a remedy, it gives you. Where it doesn't want to give you a remedy, it doesn't give you. It's as simple as that. The endeavor is what we find is the endeavor is to try and cover everybody, social welfare. But in the process of doing social welfare, you are harming the act as it stands. Legislature can enact. There's no reason why the legislature can't enact. But the legislature doesn't want to or just hasn't. If it hasn't, it hasn't. That's as simple as that. As
You're saying a service. Suppose there is a service. There are employees in that service. Unless you relate that to business,
yes,
it goes out of the expression industry.
Yes. And if there's an employee.
For example, a hotel industry, we say.
Yes.
That is essentially a service.
Yes, it is a service industry. Yes.
So you have to relate it to business then.
That's right. And correspondingly, my lords, if it is a service industry or if it is an industry for that matter, but the man is not a workman, he's out of the act. It's both ways.
Short question. Food Security Act, under which the daily food to be midday meals is an obligation of the government.
I'm sorry, I didn't get that.
Midday meals under the Food Security Act is an obligation of the government. What they have done is that they have hived it off to large number of companies which manufacture, which make food and supply day to day. It so invariably happens that all of a sudden they realize that one particular industry is not supplying food properly. And then government takes it over and then does the supply directly. If the industry is doing it, it falls under the definition because those contractors are purely and completely under the doing it as a business. The moment it hives it off, it is directly under the government, then it is not an industry. But look at it from a different perspective. So far as those workmen are concerned, they are continuously there. In first instance, they are under the contractor. In the second instance, they are under the government. So therefore, their access to the act would terribly be dependent on whether the government does it directly or not.
I follow. It may be unjust, but unjust does not make it correct or legal. Now, the point is, first of all, persons engaged by a contractor are not workmen under 2S of the ID Act. Your lordships are well that contract labor are not workmen. No, I'm just driving, I'm explaining my point of view. So therefore, while they were working with me through the contractor, they were not my workmen. Technically, when the contractor leaves, he takes his workmen with him and goes. So there are no workmen left behind. But if there are workmen left behind and they join my service, from that date onwards, they are not doing industrial activities.
There are not.
Because from that day onwards, there's no industrial.
Not in the act.
Not in the act.
That means who does the work or activity you are emphasizing, rather than what the activity is.
That's right.
Not activity based, it's industry based.
Activity will be there.
Manoj, bear in mind, as contract labor, they're not workmen. This court is held so.
Correct.
And when they come, so until that time, they are not covered by the act. After they come back directly into my control, if I'm not doing any manufacturing, etc., then they're not covered.
You are saying that don't go for purposive interpretation, go for literal.
Go for?
Literal. Literal interpretation.
Manoj, purposive interpretation has to be permissible.
Yes.
It cannot be purposive interpretation going beyond the statute.
The text is clear, don't have any further inquiry, is
That's
what you say.
That's why Justice Sujata Manohar in her
Vagueness, understand.
Know the intent behind the words.
Once again, Manoj,
Thank you for sparing time for us.
thank you for a very pleasant hearing.
Wonderful assistance. Yes, Mr. Sen Gupta is online. No? Now please connect Mr. Sen Gupta.
Then they come under the.
Am I audible to your lordship?
Yes, Mr. Sen Gupta. Yes. Thank you very much for joining us.
Lord, it is a privilege to get an opportunity to argue before so many honorable judges, which we do not usually get. And Lord, it is also a privilege to make submissions before so many learned lawyers who are before your lordships. Now, Lord, I shall be very precise in my submission. I say, Lord, before we go to anything else, kindly come to the Industrial Disputes Act, which has this 1947 Act has its objects and reasons. Now, these objects and reasons clearly say why it is experience of working. Do you have a lordships for the Industrial Disputes Act before lordships?
Yes, sir.
Page one of this book.
Page one, no?
After Roman pages, first page.
The experience of the working of the Trade Disputes Act 1929 has revealed that its main defect is that while restraints have been imposed on the rights of strike and lockout in public utility services, no provision has been made to render the proceedings institutable under the Act for the settlement of an industrial dispute, either by reference to a board for settlement or inquiry counter, so as to make it binding on the parties to the dispute. The defect was overcome during the war, empowering under Rule 81A of the Defence of India rules, the central government to refer industrial disputes to adjudicators to enforce their awards. Now, we are pausing here for a moment. Initially, the Trade Disputes Act 1929, there were defects which is noted. One of the purpose is to get away with it. And the purpose says that kindly see is being kept in force by the Emergency Powers Continuance Ordinance 1946 for a further period of 6 months. And as the industrial unrest in checking with this rule has been proved useful, is gaining momentum due to stress of post-war industrial readjustment. The need of permanent legislation is in legislation in replacement of the rules is self-evident. This bill embodies the essential principles of Rule 81A, which are proved generally acceptable to both employers and the workmen, retaining intact, for the most part, the provisions of the Trade Disputes Act 1929. Now, my lord, there, my lord, the two institutions for the prevention and settlement of industrial dispute that remain mentioned. I shall not take your lordships to the details of it. The objects and reasons are before your lordships. Now, my lord, the bill also seeks to reorient the administration of the conciliation machinery. This is another aspect. Now, for whom? These aspects are for whom? Are for the working class. Another important new feature of the bill relates to prohibition of strikes and lockouts. Now, here I pause for a moment to say that I am not in agreement with the submission put forward by my learned friends that this is a pro-labor legislation. No. It's a balanced legislation which takes its cover interests of labor as also interest of employers. Why I say so? It will be clear from the preamble to the Act, where it says that purpose is to, Lord, may I, just for a second. Lord, an act to make provision for the investigation and settlement of industrial disputes. It doesn't stop there. And for certain other purposes. Therefore, investigation and settlement of industrial dispute is paramount thing. Now, there cannot be an industrial dispute unless there is an industry. Therefore, when we talk about as legislation which makes room for settlement of industrial dispute, it must necessarily relate to industry, and it talks about industrial disputes, and the primary purpose is to preserve and maintain industrial peace and harmony. Now, when we say industrial peace and harmony, kindly see two definitions. Before we go to 2J, Lord, 2G, my esteemed friend Mr. Kama has placed before Lordship. Employer means in relation to an industry carried on by or under the authority of any department of the central government or state government, the authority prescribed in this behalf, or where an authority is prescribed, the head of the department. But this does not, in my very respectful submission, throw any light on the question, what is an industry? It says, in relation to an industry, so and so will be the employer. So and so will be the employer. And the next clause makes it further clear, which says, in relation to an industry carried on by or on behalf of a local authority, the chief executive officer of that authority. Now, if we read this in two parts, one is it contemplates an industry carried on by or under the authority of any department of the central government. And second part, industry carried on by or on behalf of a local authority. And then specifies who will be the employer. Therefore, my respectful submission will be that the Act itself contemplates industry carried on by the central government and by or on behalf of local authority. Now, Lord, if I take your lordships to the definition of industrial dispute, 2K. Industrial dispute means any dispute or difference between employers and employers, or between employers and workmen, or between workmen and workmen, which is connected with the employment or non-employment, the terms of employment, or with the conditions of labor of any person. Now, kindly pause here for a moment. It postulates a difference between employers and employers. If it is solely for the purpose of giving relief to the working class, then employers and employers dispute would not have come within the parameters. And then between employers and workmen, or between workmen and workmen. So two groups of workmen are having divergent views. That affects industrial peace and harmony. And therefore, that has to be resolved. Kindly see with this is not all. Which is connected with the employment or non-employment, or the terms of employment, or with the conditions of labor of any person. Now, Lord, employment, non-employment, conditions of labor. Now, Lord, if that is so, then Lord, read with the earlier definition, which contemplates industry carried on by central government.
Mr. Gupta, can you hear us?
Yes. Yes, very much. Some other, yes, also we hear.
You carry on.
Yes. Now, Lord, I shall take your lordships to the basic arguments which have been advanced on behalf of the labor and the arguments advanced on behalf of the employer. The working class, they say, where do you go? Where is the alternative forum? Lord, I am in one with them. The forum as provided under the Industrial Disputes Act cannot be substituted by tribunals and other things relating to government employment or public employment. Why? But the industrial tribunals have different powers. One is, as your lordship's court have held in a federal court judgment of 48, that industrial tribunals have more power than a civil court in the traditional sense, because it can create contracts between the employer and the workman. For example, a wage dispute is referred to a tribunal. Tribunal says, no, the wage structure should be this. So, tribunal is altering the wage dispute by prescribing the new wage scale. That means it can create a contract. If a person is terminated, the tribunal will say, you are reinstated, go there. That means imposing a person who was terminated on the employer. Therefore, the purpose of the Industrial Disputes Act becomes clear from this, that the purpose was to protect the persons who are in the industry. If that is so, then the entire act has to be interpreted from the angle of the working class. Even though, if I say even though, there are provisions checking the rights of workmen, checking the rights of workmen. Say, for example, strikes. The restrictions are put there. You can't just go and strike, well, I go on strike today. There are methodologies, procedures prescribed from that. And there are provisions for punishment if you do not go by that. Therefore, that's a check on the workmen. So if it is done as a one-sided legislation, then there could not have been any check on the workmen. Therefore, my lord, I read it as having a balanced view. Now, if a balanced view leads us to this reading, that this industrial establishment calls for consideration, kindly see KA once more, 2KA, industrial establishment or undertaking means an establishment or undertaking in which any industry is carried on. Therefore, whenever there is a mention of industrial establishment, that necessarily means that there an industry is carried on. That has got the blessings of the legislature. Now, my lord, I shall take your lordships through some other provisions which are relevant for determining this question. If your lordships kindly see, Industrial Disputes Act schedules. My lord, Schedule 1 deals with, as your lordships have already seen, industries which may be declared to be public utility services. And there, your lordship will find many. Yes, yes, Lord. There are services, service in hospitals and dispensaries. Doesn't make any distinction between hospitals and dispensaries run by government or local body or a private employer. Now, as it is suggested by Mr. Kama, read it as it is. Then your service in hospitals and dispensaries cannot be curtailed. It will go to anybody. Thereby, the government comes in. Service in any oil field. Oil field may be done or treated by government or otherwise. Next period, kindly sees 28. Industrial establishments manufacturing or producing nuclear fuel and components, heavy water and allied chemicals and atomic energy. Therefore, this is something which one may say it's a sovereign function. If that is so, then it is not an industry. But such a function is being assigned to an industrial establishment coming under the first schedule. Therefore, my lord, in my very respectful submission, that these types of industries having found place in Schedule 1 make it abundantly clear that governments are not excluded. Now the question arises, if the government is not excluded, what else is? If I say that nothing is, here my lord, if your lordship kindly comes to section 9, section 9, A, 9 capital A. Notice of change shall affect such change within such and such time where the discharge is effected in pursuance of any settlement. B, where the workman likely to be affected by the change and persons to him the fundamental and supplementary rules, civil services, civil services, temporary service rules, civil service regulations, rules or the Indian Railways Establishment Code, or any other rules or regulations that may be notified in this behalf by the appropriate government in the official gazette. Now, Lord, there was no point in making this provision mentioning that when the workmen likely to be affected or belong to these industries. That means they can belong to the industry, but 9 capital A will not apply to them. Therefore,
Yes, please.
yes. Now, Lord, apart from that, another aspect is 11 capital A, as your lordships have already in extension discussed during the deliberation. But I just add one of two words. 11 capital A was introduced Section 11 capital A of the Industrial Disputes Act, where an industrial dispute relating to the discharge or dismissal of a workman has been referred to a labor court tribunal or national tribunal for adjudication, and in the course of the adjudication proceedings, tribunal, the labor court tribunal, national tribunal, as case may be, is satisfied that the order of discharge or dismissal was not justified, it may, by its award, set aside the order of discharge or dismissal and direct reinstatement. Kindly mark this: direct reinstatement of the workman on such terms and conditions, if any, as it thinks fit, or give such other relief to the workman, including the award of any lesser punishment in lieu of discharge or dismissal as the circumstances of the case may require. Provided that in any proceeding under this section, the Labour Court Tribunal, National Tribunal, as case may be, shall rely only on the materials on record and shall not take any fresh evidence in relation to the matter. Now, no tribunal no tribunal
Yes.
no tribunal constituted by the government for the government employees, by the parliament for the government employees, gives this right to any employee to have his punishment reassessed by an independent body. As it was put. If it does not appear, it does not appear. No. So, if you read the statute, only because of 11 capital A, this power is given, no other remedy. Therefore, my lord, this is a power. This is an authority which inures to the benefit of the working class. Taking all this together, kindly remember we are interpreting a provision of the Industrial Disputes Act, namely 2J. And not for this purpose, before taking your lordship to this, I was referring to only not two cases, 3 cases. One is KIR 78 Supreme Court, page 474.
Bangalore, what is it? No, which one? Which one is?
Yes.
It's KCP Employees Association. Yeah, 70.
What is the first title?
Cost title is Lord KCP Employees Association, Madras, versus the management of KCP Limited.
You have the cross SCC citation.
KIR 1978 Supreme Court, page 474.
We are asking you, do you have the cross SCC citation?
Cross SCC citation. I'm sorry, my lord.
2 SCC 42.
1878, volume 2,
SCC page 42.
42.
Yes.
Kindly come to the last paragraph. In industrial law, interpreted and applied in the perspective of Part 4 of the Constitution, the benefit of reasonable doubt on law and facts, if there be any such doubt, it must go to the weaker section, labor. But if this is the principle and it has been followed for all these years, so that is the test. If there is any doubt, benefit of doubt shall go to a particular category. Now, that there is doubt cannot be questioned. Unless there is a doubt about the interpretation of industry, the matter would not have troubled up to this court at this level after 48 years. So there has been doubt. Some court has taken this view, some court has taken that view, some court has approved it. Ultimately, it has traveled up to your lordships. So doubt is there. Now, my lord, in resolving that doubt, the benefit of doubt must go to the weaker section level. Therefore, it should be interpreted in a way which comes to the benefit of the working class. That is one of the fundamentals of interpretation. My lord, this has been followed in, my lord, 2 subsequent cases. EIR 80 Supreme Court, page 1896. 1896.
SCC citation also, Mr. Sengupta.
Yes. SCC citation 1980 का पे SCC किया है Lord, Lord,
So if it's Gujarat Steel Tubes, it is 1982 SCC 593.
2 SCC
593. Gujarat Steel Tubes.
593.
593. Gujarat Steel Tubes Limited versus Gujarat Steel Tubes Mazdoor Sabha.
Not I shall place only two paragraphs. First is yes. My lord, last 8 lines of paragraph 20, where workmen on 100 rupees a month they demand immediate negotiation. The reason is that privatizations have no patience beyond a point. Now and here, by negotiation, is the shop floor clamor. In this very matter, although the controversy before the arbitrator fell within a small compass, it took a year and 90 printed pages to decide. Invariably followed by a few years and 130 printed pages for judgment in the High Court and a longer spell in this court, with slightly lesser length of judgment. Which workman under third world conditions can withstand this wasting disease while hunger leaves no option save to do or die? Raw life, not rigid logic, is the mother of law. So look at the raw life situation. A person is putting his labor, getting his money, purchasing food for his children. He cannot wait till the tribunal, in the nature of administrative tribunal, decides. Now, the next paragraph of this judgment, which I am tempted to show, is 147.
Paragraph 147.
But it starts with
147.
yes, 147. It starts with the last part of our conclusions. Really, may your lordships have got it? The last part of our conclusion relates to the relief which must be fashioned with an eye on mutual equities. We cannot ignore a few realities since law is not dogmatic but pragmatic. Without temporizing on principles, the management's limitations in absorbing all the large number of discharged employees all at once, when still the employees, the raw material is scarce, it is a problem. Likewise, their inability to pay huge sums by way of back wages or otherwise without crippling the progress of the industry. Now, my lord, this being the situation, kindly come how the court views it. Last 8 lines. Every proposal must be bottomed on the basic economic fact that the beneficiaries are from the many below the destitute line. This court has, in a very different context though, has drawn attention to the Gandhian guideline. This is what I am relying upon. Whenever you are in doubt, apply the following test. Recall the face of the poorest and the weakest man whom you may have seen, and ask yourself if the step you contemplate is going to be of any use to him. Similarly, if your lordships feel that a step, yes,
Yes, yes, Mr. Gupta.
yeah. Therefore, my lord, Supreme Court itself has applied this Gandhian guideline which, if applied in this case, will take your lordships to a decision which will be not legalistic, but realistic. Judged by that, now the last judgment on this is 1982, 1 SCC, page 117. My lords have kindly got it. But here, the question arose, if I may tell your lordships, for your lordships' convenience, that your lordships don't have to go through all these pages. There was a difference between workmen and the employer. The employers say, well, we will promote as we like. Promotion is a prerogative of the employers. The employees objected. Matter went to the tribunal, and the tribunal took the classical view. Well, the employee has no right of promotion. Therefore, it has been done that way. No interference is called for. The matter was then brought up before this honorable court directly without going to the High Court. Now, I'm not kindly see. The question argued was, well, these persons who were not promoted but kept where they were, they are victimized. Kindly mark this expression, victimized. Now, my lord, Mr. Pai in that case argued, following in Bharat Bank's case, victimization is an ordinary English word, which means that a poor person has become a victim. In other words, that he has been unjustly dealt with. Now, my lord, a submission was made on behalf of the management in that case that victimization had acquired a special meaning in industrial disputes and connoted a person who became the victim of employer's wrath by reason of his trade union activities, and that the word could not relate to a person who was merely unjustly dismissed. This submission, however, was not considered by the court. When, however, the word victimization can be interpreted in two different ways, the interpretation which is in favor of the labor should be accepted, as they are the poorer section of the people compared to the management. Then what KCP is followed. Then KCP employees association is followed. That paragraph I have.
Mr. Sengupta, just for a second. There was a three-judge bench matter listed at 3 o'clock. This matter is going on and likely to take some more time. So that bench is discharged. We'll try to list that Aravali matter, maybe next week.
Maybe.
Monday or Tuesday. We'll see that where I can accommodate it.
As your lordships please, Lord. As your lordships please.
We will continue with your matter, Mr. Sengupta. There is another matter which we are adjourning.
As your lordship please.
We will continue with your submission.
Now, your lordship will be continuing now.
Yes, 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 yes.
Yes. Then, Lord, I take your lordships to the other aspect of it, that your lordships are interpreting the word industry. That's a word relatable to reality. What is an industry? Now, Lord, kindly have a look at these three citations that I've made. If there are two ways of looking at it, look at from the angle which will benefit the poorer section. That means labor. The employer may be very, very right in saying either it is there or it is not there in the statute. Therefore, it's very clear. Now, if that is so clear cut, then no doubt arises. The matter would not have been there for 48 years and coming up to this level. So, a doubt arises, doubt exists, and this is how it has come. Therefore, industry should get a liberal meaning for the benefit of the working class. Now, my lord, if I may say a few words more on this, kindly come to the Bangalore water supply judgment. Paragraph, first of all, is Justice Beg's judgment. What's the phone now? Not in that judgment, I shall not trouble the lordships with a major part of it. I'll just draw your lordship's kind attention to paragraph 26 and 27. May I start now? Legalese and para 26, Justice Beg's judgment. Starting with legalese and logomachy have genius.
Yes.
Legalese and logomachy have the genius to inject mystique into common words, alienating the laity in effect from the rule of law. What is the concern? What is the common worker or ordinary employer to do if he is bewildered by definitional dilemma and is unsure whether this enterprise, say a hospital, university, library, etc., Board, Chamber of Commerce, is an industry at all? But for the last 48 years, they have known what is industry. Now, if your lordships take a view, which will say, no, your industry establishment is not an industry, and but they will be at a loss totally. Then has lost uncertain erudition, and serious cases have even cancelled each other out while reading meaning. I do not think, said Lord Justice Diplock, that anywhere except in a court of law, it should be argued with gravity that a Dutch barn or grain and fodder stores or any ordinary firm buildings are properly described as repositories. A Gloucestershire farmer would say that they were farm buildings and would laugh at their being called repositories. In the same spirit, Justice Stamp rejected the argument that the carrying on the business of a cremation or materials to any process, if a commission involved subjection of goods or materials to any process within section 271 of the Income Tax Act as a distortion of the English language. Protest against subjecting the English language and more particularly simple English phrase to these kind of process or philology and semantics. Maxwell. Historica is anathema for law, affecting the common man in the commerce of life. And so the starting point for our discussion is the determination to go by the plain, not possible sense of the words used in the definition, informed by the context and purpose of the statute. Illumined by its scheme and setting and conceptually colored by what is an industry at the current developmental stage in our country. In our system of precedents, our endeavor must be, as argued by counsel, to reconcile prior pronouncements, if possible, and to reconsider the question altogether, if necessary. There are no absolutes in law, since life which it serves is relative. What is an industry in America or the Soviet Union may not be one in India. And even in our country, what was not an industry decades ago may well be one now. Our judgment here has no pontifical favor, but seeks to serve the future hour till changes in the law or in the industrial culture occur. Next paragraph. Law, especially industrial law, with the regularities which regulates the rights and remedies of the working class, unfamiliar with the sophistications of definition and shower of decisions, unable to secure expert legal opinion, what with poverty pricing them out of the justice market and denying them the staying power to withstand the multi-decade litigative process, de facto denies social justice. If legal drafting is vigorous, definitions indefinite, and court rulings contradictory, is it possible that the legislative chamber are too preoccupied with other pressing business to listen to court signals calling for clarification of ambiguous clauses? A careful prompt amendment, kindly mark this sentence, a careful prompt amendment of section 2J would have preempted this docket explosion before tribunals and courts. This court, perhaps more than the legislative and executive branches, is deeply concerned with law's delays and to devise a prompt delivery system of social justice. But just pause here for a moment. It says that unable to secure expert legal opinion. What is meant by these words? Layman, the common man in the street. No, this is an industry, this is an industry. And secondly, Lord, what has held the field for 48 years. A person was born there. Then, now that he is 48 years of age. And now he is to be told that, well, look here, you are not a workman because your establishment is not an industry. We go by the rigid definition, not by what was intended to be included. Why I say intended to be included, I shall explain now. Next, my lord, I'll take your lordships to Justice Ayer's judgment.
Yes, sir.
In Bangalore water supply. My lord, Lord, kindly keep this in mind and read it with the Constitution itself. Your Lordship, as a look at the Constitution of India, the starting point, we, the people of India, we have to say, we, the people of India, have been solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic and secure to all its citizens. I'm coming to that later on. First is, the people of India are constituting India to a sovereign republic. The word sovereign has been discussed during this discourse. But see, it has to be given a meaning. This is the goal of the Constitution. Can a statute go beyond what is the requirement of the Constitution? Is a question that your lordships will have to consider. Then, and to secure to all its citizens justice, liberty, equality, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. Therefore, this was the purpose of the constitution makers. Say that we are people of India are constituting India to a sovereign, socialist. I will not pause here for a moment. These expressions, socialist, was not there. It was introduced by the 42nd Amendment in 1976 with effect from 33/1/1997. And when the judgment was delivered, 78 February, I believe. So we are already in the socialist jamana. Constitution has been so amended that whether we like it or not, whether the employers want it or not, this has to be given the meaning that a socialist society demands. Therefore, this expression, this expression socialis takes us to the concept that was propagated in the judgment of Justice Krishna. Lord, now, Lord, I take your lordships to the judgment of Justice Iyer, 2 paragraphs.
Citations,
Yes, citation is,
Bangalore.
I give you lordship. There is 1978 to STC 213.
You can just refer to paragraph and the author. You want to refer Justice Iyer or Justice Beg or Justice Chanchud?
Yes. Justice Iyer is now what is being cited by me.
Yes, please point out paragraph also.
Yes. Paragraph, in my book, it is paragraph 140 and 141.
That's right. 140, industry as defined in section 2J.
That's right.
Yes.
Now, Lord, I would say that this read as a whole gives rise to a number of questions which one might say is not acceptable. As Mr. Kama rightly said, no, this is not acceptable. The point is not whether it is acceptable or otherwise. The point is the economic relationship such as found in trade or business between the head who employs and the others emotively flock to render service. In one sense, there are no employers and employees, but crusaders all. In another sense, there is no wage basis for the employment, but voluntary participation in the production, inspired by the lofty ideals and unmindful of remuneration, services, conditions, and the like. Supposing, my Lord is correct, there is an ashram. Yes, Lord. Lord, I better start from the second species of charity.
Yes.
The second species of charity is really an allotropic modification of the first. If a kind-hearted businessman,
Lord, this is not 140 as your lordships are referring.
107.
110.
Earlier
107. It may be 142, 140 in AIR.
AR,
This
AR.
is Sedu's,
AR version.
it's 110.
110 Justice Krishna here.
107.
Yes, supposing
107
there
is the
is an
second category. 106 is the first, 107 is the
that AIR are discussing different aspects from
107. 107.
Para numbering is different.
Different.
yes, yes.
Yes, yes. Kindly read.
Focus on. That's where he said the goods.
This is the second section.
This paragraph starts at the heart of the trade and business are analogous activity in organization with an eye on competitive efficiency.
Yes.
110. Please go to 107.
107.
Yes.
The second species.
Second species.
Now, the second species of charity.
Yes.
A kind-hearted businessman.
It begins at 102, and charity be industry.
Lord, the second species of charity is really an allotropic modification of the first. If a kind-hearted businessman or high-minded industrialist or service-minded operator hires employees like his non-philanthropic counterparts and in cooperation with them produces and supplies goods or services to the lowly and the lost, the needy and the ailing, without charging them any price or receiving a negligible return. People regard him as charitable disposition and his enterprise as a charity. But then so puts little whether he makes available the products free to the poor. They contribute labor in return for wages and conditions of service. For them, the charitable employer is exactly like a commercial-minded employer. Now, so employer-employee relationship when it comes, I am employed there. I get my wages. I do my duty. You say you are charitable. But so far as I'm concerned, I am no part of your charity. But I'm a part of the establishment.
The employer does with his money, the employer.
Yeah.
Yes. But then, so far as the workmen are concerned, it was little whether they makes available the products free to the poor. They contribute labor in return for wages and conditions of service. For them, the charitable employer is exactly like a commercial-minded employer. Both extract hard work, both pay similar wages, both treat them as human machines, cogs, and nothing more. The material difference between the commercial and the compassionate employers is not with reference to the workmen, but with reference to the recipients of goods and services. Now, a person may be philanthropic, trying to do charitable jobs, but at whose cost? At the cost of the labor. The material difference between commercial and the compassionate employers is not with reference to the workmen, but with reference to the recipients of the goods and services. Charity operates not vis-a-vis the workmen, in which case they will be paying a liberal wage and generous extras with no prospect of strike. The beneficiaries of the employer's charity are the indigenous consumers, Indian consumers. Industrial law does not take note of such extraneous factors. But no one can dispute this. Yes. But regulates industrial relations between employers and employers, employers and workmen and workmen and workmen. From the point of view of the workman, there is no charity. For him, charity must begin at home. From these terms, second group may legitimately and legally be described as industry. The fallacy in the contrary contention lies in shifting the focus from the worker and the industrial activity to the disposal of the end product. Now, Lord, this, as far as this is concerned, I do it in one way. Yes, sir.
This way, this way, this way, this way. Yes.
May I start, Lord?
Yes, yes, yes.
Yes. Lord, so focus is being shifted from the worker and the industrial activity. Just pause here for a moment. On the one side, he is a compassionate employer who, at the cost of my labor, gives something to poor people. The same labor I put in, if it is not a charity by a commercially minded employer. So the work that I do, question is whether it will go under the heading that charitable labor or simple labor who earn wages for rendering service. But here we are concerned with industry, and therefore whether it is run by philanthropic organizations or persons or profit-minded employer means little. Why? Why I say means little? Only thing is that just wait a minute. Simply because why I say the nature of work determines whether it's an industry or not. It's not the owner of the establishment that determines whether it is industry or not. Therefore, if this is not to be decided by the nomenclature of the employer, but by the jobs rendered, work rendered by the workman, then, my lord, it is, in my very respectful submission for your lordship's kind consideration, will be going away from the purpose, object of the act. Now, my lord, if I may just draw your lordship's attention to paragraph 132, that means your lordship's paragraph will be just one after the one, starting with the heart of trade. The heart of trade or business or analogous activity.
Next still. But they will take it tomorrow. Let's pick this or this.
the heart of trade or business or analogous. Yes, ma'am.
We got it, we got it.
Yes.
Not a private.
Is organization with an eye on competitive efficiency.
Milord,
By
for the
hiring,
lordship says 110.
Is our cor-
Otherwise, the record will show.
No, now this is 110 only.
The record should also show.
Because now Mr. Sen Gupta is referring to SEC paragraphs.
Yes, but it's gone down to 25, which is AIR
We'll
paragraph.
correct it.
That probably continue to.
Audio.
Yes, Mr. Sen Gupta.
yes. The heart of trade or business or analogous activities organization with an eye on competitive efficiency by hiring employees, systematizing process, producing goods and services needed by the community, and obtaining money's worth of work from employees. If such be the nature of operation and employer-employee relations which make an enterprise an industry, the motivation of the employer is the final disposal of the products of profit is immaterial. That is why I'm emphasizing. In my respectful submission, this gives a correct exposition of law, judged by the touchstone of the purpose and object of the Industrial Disputes Act, as also the Constitution of India as it stood then, and as it stands now also. Therefore, I think, Lord, I can continue for some time, or I.
Mr. Sen Gupta, we want to wind up this matter by 4 o'clock.
Yes.
So we just here 10 minutes, Mr. Attorney General also. So
Yes.
if you want to wind up, you can.
No, I said I have a lot to say, but my Lord, time constraint is there. That I understand. Your lordships are sitting with this case for so many hours.
You kindly give your synopsis also, please, if there is any synopsis or any written note if prepared, that will also help us.
No, I shall try. I shall try. I shall try. The nodal advocate had contacted me, and my Lord, I can hand over it to him so that not it goes to your lordships.
Yes, please. If you want to add anything orally, Mr. Sen Gupta, you can still do it. We can stretch it for 5 minutes more. There is no issue. If you feel that there is something orally you would like to, any concluding remarks or anything, please, you are most
Yes.
welcome.
Yes, not just a minute. Appropriate. The only thing I would not trouble your lordships with the question that's argued, 6 judge, 7 judge. I believe that is concluded by your lordship's judgment.
Who has declared? Or declared? Cited.
No, it's judgment delivered by
Saudi Arabia.
5 judge bench, of which my Lord the Chief Justice was a party.
So that is Trimurti.
Trimurti fragrance.
Yes.
So there, it has been very categorically held that, well, a judgment was delivered on behalf of Justice Banerjee and my Lord the Chief Justice and Justice Sundaresh and Justice Surya and Justice Hemant Gupta concurring. So their question was whether this is 5 judge bench, that's 7 judge bench, how could this be done? as was sought to be argued before your lordships. Paragraph 19 only I shall refer. It is settled that the majority decision of a bench of larger strength would prevail over the decision of a bench of lesser strength, irrespective of the number of judges constituting the majority.
Yes.
Therefore, there can't be any controversy over this. A 6-judge bench has been overruled by 5. Nothing of that sort.
Thank you very much, Mr. Sengupta. Thank you.
I'm obliged to your lordships for giving me.
Very much. We will request you to give the one written note also as per your convenience.
I shall. Since it has fallen from the court, it's my duty.
Thank you very much. Thank you for assisting us and thank you for sparing time for us.
I spend the time for the nation.
Thank you very much. Yes, Mr. Attorney.
May I be excused, if you don't mind? I have just one request. I have 3 learned juniors.
Can you take Mr. Kama mic? Yes.
I have just one request, rather unusual one. I have 3 learned juniors who assisted me, and they're very keen to have their names in a 9-judge bench. So is it all right with your lordships if that is done? Appearance. I'm obliged.
Your assistance is always, of course, that all of us must acknowledge that.
They've been very helpful.
This is how these youngsters, they put their hard work and labor. Yes, that must be acknowledged. Thank you so very much. Please give their name. So ask Mr. Sengupta also, he is assisting constantly.
After the attorney, your lordship will give me 10 minutes.
No, 10 minutes. We'll just wind up. Maybe that you are not required to say anything. Yes, Mr. Attorney, in 5.
There are 2 points.
We have 10 minutes, 5 minutes for 6 minutes for learned attorney and 4 minutes for NAPCO.
So then permit us to file.
No report. Because then
So then permit us to file additional written statements.
Yes.
Additional written. I will take 2 minutes only and file additional.
Additional note can always be submitted. We have already, in fact, permitted the party that you can always supplement.
Your Lordship, please. We almost heard the last submission. An invitation to the court to go into Marx's surplus theory of value and all those wonderful expositions on what constitutes profit and why accumulation of capital will always happen when there is an exploitation. And therefore, this legislation, which is a proper legislation, must keep all that in mind. I will not say no to that. But the question is, what are those extraneous factors? What are those extra factors which should be either kept out or should be reckoned? So in the course of identifying those factors which should be kept out or reckoned, I find Bangalore water supply has gone somewhere. The pendulum has swung on one extreme side. That's why in my opening submission, I said as far as the 3 tests are concerned, nobody can go beyond those 3 tests. Take a trade, take a business, take any calling, those 3 tests will definitely be applicable to them. Therefore, I would say that while all the triple tests is a good test when you keep in mind trade, business, etc., but that cannot be the end all and the end all test. And while industries may answer these tests, all activities that meet this test would not be industries. Need not be necessarily industries. Therefore, you fall into a conceptual error. I'm using the word error with a lot of reservations. conceptual error when you say keep the mind of an employer who is with you, the employee is with you, the workman in your mind. So all of the factors where it is a governmental function or a charitable activity, they will all recede to the background. All the only focus will be, are you employing somebody who is probably an exploited character? So exploitation, I suppose, is something so inevitable in the process of accumulation of capital. But that does not mean that every activity where a person would like to employ somebody, including a government where it wants to discharge some functions constitutionally mandated, there is something uppermost in the mind is not exploitation, but to do something beyond exploitation. So if you focus only on exploitation and anti-exploitation, focus on the act, and in a particular case, well, if it wants to be, the court was to read it in favor of the weaker section, you will definitely read it. The question is whether you should pay bonus, whether it is a fair wages or not, unfair labor practice, you will definitely read it in favor of the workman. But the question is whether the activity itself is an industry or not. To say put it entirely on the focus of the weaker section, there could be a problem. Just I want to flag that. And I have a note. Can I handle the note? I mean, one can always cite judgments to say that whatever be the nature of a legislation, welfare or tax or criminal law, court will not probably rewrite the law. You can, in case of casus omissus, will say, I will be very careful, but I may still read something into the law. Lord Henning said, ironing out the creases. But ironing out the creases will be a very narrow area where you must make a meaning to the law where it is not so clear. But where you go beyond that, ironing out the creases and do something beyond that, perhaps that would amount to a rewriting. And one may justify it saying, well, I found all the honorable judges said in Bangalore Supply, what is the legislature doing? It's gone to sleep. What shall we do? So therefore, I think there's a long compulsion which persuades the court to reach a very highly humanistic understanding, if you put it like that. I will not find fault with the humanistic value which persuades the judges to go into that. But then while doing that, if you probably began to read into the statute or write into the statute where you could not have written them at all. It's in that context, I thought Bangalore Supply is a little overbreadth, and that may require some kind of a moderation. And certainly that's why I'm not entering into all those detailed discussions of the various provisions of the Act. Now, you'll also be invited to look at public utility services and then various provisions of the Act. Unless an activity qualifies the fundamental test of being an industry, that because it's a public utility service, the reverse is not necessarily true. Therefore, in those cases where an extra protection both for workmen and an industry was required, you said the following will probably have all this protection, section 9A, 9B, 9C, section 22, etc. Therefore, otherwise, the code could have been written very differently. The parliament could have said all public industries are to be treated as industries. The parliament has not done that. And then we have an era where government came into heavy industrialization. It took up industries by itself. Jawaharlal will talk about that. But then we are no longer, I'm not saying that, well, because you have moved away from a nationalization era, something drastically different will happen as far as workmen is concerned. Workmen will always remain a workman. Exploitation will always be an exploitation. But notwithstanding that, if there are higher levels of looking at it, namely a governmental function, which deserves a different approach or perspective. Therefore, you've gone into all those, a forest department becoming an industry. It need not necessarily be so. For research is purely for the purpose of advancing social and public purposes. You may employ workmen, but then if only the consideration employing workmen, the larger social purpose of serving the community recedes to the background. Therefore, I only wanted to say, I'm not going to read this just in my note, but I thought what the court felt as external factors were not necessarily external factors. And what the court felt to be excluded were not necessarily to be excluded. So I began my submission saying that it's going to be only for the pipeline, because whatever the court may say will somehow or the other slip beyond the cup. and might have an impact on how the future law will be interpreted. Court will have to be very careful about it because it's a very, as Mr. Singh said, it's a very unusual case where we are trying to, unravel the mysteries of a particular legislation when it is already dead. So we are in a very unusual situation. Therefore, the court will be very careful that no party in the meanwhile, I think, as I said, the heart of the attorney need not necessarily against the workman. I'm certainly saying that if there is a welfare legislation, let it be so. But then how do you stretch it beyond the welfare element and say, I see something more in that? So I would probably end there, but two judgments I would like to cite and how the court may not go beyond the text of the law, even in the context of a welfare legislation. It's very often the court is troubled by the conscience of the court and say, how do I deal with a situation when I don't find an answer in the law? The text of the law does not provide an answer. Would that mean that the court will take a pen and paper and say, I will rewrite the legislation? Because we are not talking about 142. Before I read the judgment, we'll also just pick up page 3 of my rejoinder note, just quickly. Because everything turns on the first issue. I have given my rejoinder note to the court. The note. Just page 3. Just permit me to quickly scan this page and then I'll go to the judgments. Yes. Whether the test laid down in paragraphs 140 to 144 in the opinion rendered by the so and so is to determine if an undertaking or enterprise falls with the definition which is laid on the correct law. This is clarified as follows. Triple test is only one among the factors to be considered to determine whether an activity, not a body, is an industry or not. It is not a be-all and an end-all test. While all industries may answer to the triple test, all activities that meet the triple test would not be industries. Para 14A0 uses the word prima facie, which test is not sufficient to determine whether or not an activity will categorize as the industry. There are certain other additional factors that deserve to be considered before categorizing an activity as the industry under section so and so, which include what is the intent and purpose of the activity, what is the predominant nature of the activity, whether other incidental activities are integrated to the predominant nature of the activity or they are severable, whether the work person is engaged in an incidental activity as opposed to the core or the predominant activity of an establishment, like a scientific research, whether the activity is in furtherance of a constitutional or statutory mandate. These are very important. And then next page. Whether the incidental revenue generation is relevant or not. Profit making per se is irrelevant, but the context in which profit may be present or absent is relevant, specifically to see whether the profit was contemplated or otherwise. For example, in Goshala and para 9014.6 may be generating revenue, but that was never contemplated. It's merely an incident of carrying on a charitable activity. Therefore, you shift the focus to the employer, then it becomes an industry. You keep the focus more on the nature and the purpose, etc., then it doesn't become an industry. So how do you say which one is to figure? Therefore, the choice becomes very difficult. But I would say mere focus on the employer may sometimes be an erroneous proposition. These two judgments, one, this Dalco Engineering, 2010-4 SCC 378. There's a question where what will be the meaning of an establishment under the
Which one the second?
disabilities legislation? Huh?
Second judgment.
What is the other one?
Whether a private company would also be considered an establishment for the purpose of the disabilities legislation. Let me straight away go to paragraphs. You just make a note of paragraph 28 at running page 390 of the report. Then just below that, paragraph 29. The Learned Council next relied upon the principle that words in a social welfare legislation should receive liberal and broad interpretation stated by this court in Workman versus so-and-so. Nobody can have a disagreement with that proposition. Then kindly turn to the next page, paragraphs 30 and 31. The Learned Council next relied upon the following observation in Kunal Singh versus Union of India, where the court referring to the very section under consideration observed this. Section 47 contains a clear directive: the employer shall not dispense with reduce in rank an employee who acquires the disability service in construing a provision of a social beneficial enactment that to dealing with disabled persons intended to give them equal opportunities, protection of rights and full participation. The view that advances the object of the act and serve its purpose must be preferred to one which obstructs the object and paralyzes the purpose of the act. Now we go to paragraph 31. We agree that the socio-economic legislation should be interpreted liberally. It's also true that courts should adopt different yardsticks and measures by interpreting socio-economic statutes as compared to penal statutes and taxing statutes. But a caveat: the courts cannot obviously expand the application of a provision in a socio-economic legislation by judicial interpretation to levels unintended by the legislature, or in a manner which militates against the provisions of the statute itself or against any constitutional limitation. In this case, so-and-so, etc. Therefore, para 32 is what they say, and then the facts of the case, how they apply it. Then the other judgment is one in the context of Contract Labor Regulation Abolition Act, a 5 judges bench in Steel Authority of India. Para 105.
Yeah, the principle that beneficial legislation.
Para 105. The principle that a beneficial legislation needs to be construed liberally in favor of the class for whose benefit is intended does not extend to reading in the provisions of the Act what the legislature has not provided, whether expressly or by necessary implication, or substituting remedy of benefits for the provided by the legislature. If it is so that it regulates the conditions service of the contract labor and authorizes in Section 10(1) prohibition of contract labor system with the appropriate government on consideration of factors enumerated in subsection 2 of Section 10 of the Act and other relevant factors. But the presence of some of all these factors in view provides no ground for absorption of contract labor and so on. So that's why they read Section 10 of the Act. Therefore, today I think the court is not being called upon to construe it in the context of a particular dispute as to whether who should win in the context of unfair labor practice or unfair treatment of a workman, so on and so forth. Therefore, in all those contexts, court will say, I'll read it as liberally as possible. When it comes to the question of reading the statute itself for the purpose of understanding where do we land within the statute. So those considerations may not be strictly relevant, except to the extent that we will not completely close our mind to that. Therefore, if he's, as I said, the pendulum can swing either way, there's some problem. So your lordship have faced those three issues. When I started beginning to work in this matter, I thought, how will you answer this question? To be very fairly, I asked myself a question. How is the court going to answer the first question if the court was to simply say it is whether it is good law or not? So if it is, as I say, usually for a dead purpose, namely, we are going to bury this case, 47 is over, then only for the purpose of the pipeline case we're going to answer it, I think the answer may not be very difficult to answer. But I don't know whether it will cast a shadow too long on what may remain for the future. Therefore, you'll have to be very careful about what to do. I just want to add the word of caution. And it's been a great, rewarding experience for me. My wonderful team worked for more than 15, 20 days and day and night. But finally, we were closing. My last long experience and acquaintance with Justice Krishnaya, notwithstanding. I know we talk about all that here, no time to talk about that. And I know where his heart was. And I know why his mind so compassionate in everything he did. Everything he did, I know why it went this way. I can't be a commentator on how he felt and how compassion worked in his mind. But since all that is today history, but unfortunately, if you have to talk about why in an LPG situation, can we keep close our eyes to all that? I may say with a lot of reservation, we need not necessarily close our eyes to that. Because as again, before I worked on my written submission, I had to go back into the government, share my views and ask their considerations and their own reflection. And the government said the government is certainly not anti-labor. Government is certainly not anti-labor. Government concerned that as far as the directive principle state policy is concerned and the welfare of the labor is concerned, they will go at any length to find out that the labor welfare is certainly taken care of. But if you have difficulties in having a forest department to declare an industry, an irrigation department to declare an industry, or say an ACM to declare an industry, there are very, very serious concerns. We are moving towards a globalized world where we do not know how we're going to manage our domestic economy. Therefore, all that caution will probably be kept in mind. I'm grateful to you all.
Thank you, Mr. Reddy. Mr. Nabde, for
I don't propose to read on sovereign functions.
or maybe a minute.
And I will stick to it. I don't propose to read my sovereign functions. It is already there. Lord kindly read.
There.
So 2 points which warrant a reply. Number 1, Article 142, prospective overruling. Now take a case, if your lordships ultimately accept our contention and still your lordships apply the principle of prospective overruling, then it will be a judgment in my favor, but the decree will be against me. This can't be. That will be an exercise in futility. The second reason which I say is that this doctrine started from Golaknath, 1967. The court was conscious of the fact that if that entire agrarian reforms and other legislation was struck down, it would have led to chaotic conditions in the country. Therefore, the situation was radically different than what we are faced with. Here, it's a question of individual rights. It won't lead to any chaos. That is my answer to their. Second is, Ms. Jaising raised a very pertinent point, which I must answer. She referred to the first schedule and pointed out to your lordship, for example, India government mints and the security press. These are actually sovereign functions. Now, if your lordships notice that these are entries which are added by the central government, these are not original entries. Now, if your lordships look at the definition,
are from 2012 to 2018.
Correct. Now, this is the government's understanding. The question whether that constitutes an industry or not, if your lordship hold that sovereign functions are out, then of course this entry will be a nullity because it's an entry which is made. But I have a better answer apart from this. Now the word industry is used. If your lordships look at the definition of public service, the last item.
The first schedule, it says the industries which may be declared.
Yes, I am referring to that. I am referring to the word industry. Now my answer to that is that there is always a presumption that the same word used in the same statute may carry a same meaning. Very well. But it's a weak presumption. It will depend upon the context. Because every definition says subject to the context. Now kindly look at section 22, because this has to be read with section 22. The idea is to prohibit strikes and lockouts. These are vital economic activities. And that is why it need not be an industry as defined under section 2J. The industry as defined in section 2J, as I pointed out, has commercial roots. And this is something beyond that. So therefore, that is my second answer. And the third is that as far as the distinction between the labor law and the service law, the distinction lies in this, that the service law is entirely statute law. So therefore, there is hardly any scope I'm not saying that there is no scope at all, but there is hardly any scope for an industrial adjudicator to adjudicate. So therefore, your lordship will consider this in the light of while considering the definition of industry. That's all. And some details will have to be given, which if your lordship so permits, we will put them in the writing. Grateful. Yes.
May I have 2 minutes of your time, my lord?
2 minutes.
2 minutes, not more than that, I promise you.
1 minute, Jesse, 1 minute. I'm about to come.
What is?
I have 1 more minute
After
left.
you're taking away from my time.
So
That we will grant independence.
yeah. So ultimately, there was no answer to triple test, how it originates. I pointed out to your lordship, this is borrowed straight from Australia, which doesn't fit into the scheme of IDA Act. But that apart, their argument was that since Bangalore water supply is followed in several judgments, now that is hardly a ground. If the judgment is erroneous, it is erroneous. Merely because it is followed umpteen times is no ground to say that it's a correct judgment. This defies logic. That's all, my lord. Thank you.
But I'll answer that last point also with reference to decided cases of this court. To answer his last point, my lord, this court has recorded that our Industrial Disputes Act is based on the Australian Act. Because I was very also curious why normally this court cites United Kingdom decisions because we belong to the common law tradition. Of course, Australia is also part of the common law tradition. But I was wondering why. In 2 cases, right from Banerjee onwards, it is the Australian cases which are referred to. And the answer to that is because our law is based on the Australian law. And I'll put it in writing and give it to you from where I'm getting this information. So no magic about referring to Australian law. It is there. It is the parent of this act. It was a Commonwealth Act which was applicable to the entire Commonwealth lot from which this act has been borrowed. Leave that aside. My lord, as far as the learned amicus is concerned, he made reference to chapter 5B of the Industrial Disputes Act. Just take it for 1 second with you. Now, my lord, and he referred to the definition of undertaking in chapter 5B to convince you that you take this definition and not 2P. Now, the answer to that is in chapter 5B gives a separate definition of undertaking over and aside from the definite meaning that you're giving it in 2P. The reason is it offers certain benefits such as retrenchment compensation, layout compensation, and they want to exclude certain establishments. So 5B is excluding establishments which would otherwise be covered by the definition in 2P. Therefore, it cannot be an aid to interpret the meaning of undertaking in 2P. That your lordship will make a note of that. Secondly, my lord, as far as Mr. Kama is concerned, he said, let's use our common sense. And he used a rather obscene Hindi word. He said, dhanda. Now, if you want to use the expression like, first of all, judgments of this court have said you cannot use your common sense. These definitions are words of art, what we call, these are words of art, which have a legal meaning. And I will show that to you from Banerjee. Para 13, just read para 13. 1.3 in Banerjee. They specifically say you cannot use your common sense in interpreting these words. In the ordinary, non-technical sense, according to what is understood by the man on the street, that's not what this court uses. So, my lord, the word, and let me explain why. Because the word dhanda, for example, can include even prostitution. Is that a business? This court has prostitution is res extra commercial.
He is not used in that sense.
It does include, my lord. I'm sorry. This court has said it is res extra commercial.
I haven't studied Hindi too much.
No, you can exclude. Even
No, it doesn't mean that what you're saying.
My lord, even from common sense words, there are exclusions. This court says it is not, it is res extra commercial. If you want, I'll give you the judgments. It's not considered an industry. Alcohol is considered res extra commercial. Therefore, Lord, where is the question of using words like that? You have, these are words of art. used in a statute which have to be given a statutory meaning. Otherwise, my lord, the whole concept of having legal fictions will go out of the window. You can't have an artificial definition, but you can have an artificial definition by law. That is the second point. My lord, if I offended you, please ignore that. Please ignore what I had to say. I'm sorry. I should have used res extra commercial instead of saying anything. Now, the third point he raised, he said, no, a question fell from the court. I think the question was, what about supervisors? Somebody asked the question, protection. My lord, your lordship asked the question, protection. His answer was, supervisors are not protected. It is true. Managerial category is not protected by this act. Managerial category still follows the law of hire and fire. Tomorrow, if
It is expressly excluded.
yes, tomorrow, that's no answer. It's no answer, my lord, to say that we should not get the protection of the idea. Legislature has decided who gets protection, who does not get protection. So therefore, my lord, the mere fact that supervisors are excluded, it doesn't mean the workers should be excluded. My lord, the last thing is the word industry. Now, my lord, supposing I say this honorable court is very industrious in the way in which they go about their work. Are you performing an industry? No. There, again, you come to the same conclusion that words must carry the meaning in a statute in relation to an organic whole. You look at the statute as a whole, the word industrious is capable of many meanings, but you will choose the meaning which is relevant to this statute, to the interpretation of this statute, object and purpose. And finally, my lord, a question from Justice Bagchi about adding value. My lord, that is the third limb of the triple test which has not been discussed. It says production of goods and services of value to the wishes and needs of the community. That's where value is coming. If you give me something which is of interest to the community, then you come under the triple test. That is why spiritual is excluded. Spiritual is for me individually. So, my lord, we have not discussed value is added by releasing what you do to the community at large in public interest. So you look at three arms of the trust together, my lord. That's all I want to say. Thank you very much.
Thank you.
Keep
Thank
in
you very
mind
much, both
that
sides.
reference order is important because the three judges bench where Krishna Iyer was there, then the matter went, because subject was 6, they went before 7 judges. That's how it happened. I thought important to keep it in mind. And Banerjee was Chandrasekhar Iyer, Bangalore was supplied as Krishna Iyer.
While you prepare your notes, and hand over to us, please take note of one decision.
Your lordship permit us to.
You like one.
847. 1 minute, Mr. Naf.
Sorry, could your lordship repeat that?
75, volume 2, SCC 847. I was wondering why Justice Bhagwati, being on the bench in Bangalore, did not pen an opinion. This is Justice Bhagwati's opinion, and whatever Justice Iyer has written, perhaps is inspired from this decision. Look into it.
Milon, just one thing, Mr. Gupta gave you a.
I thought.
Justice, Milon, let me just tell you this piece of information. Mr. Sen Gupta referred to a judgment.
We gave it to
Milon,
So permit us to file within 1 week.
Yes, no, we will, yes, instead of 1 week, we can grant you slightly more time. After these small breaks, we are opening on 5th. So request is that in the opening on 5th or 6th, by 6th of April.
Very well.
Milon, I just want to let you know, Mr. Sen Gupta referred to a judgment. It is cited in para 4 of Justice Banerjee's judgment. That is Western India Match Company. Unfortunately, it is not reported in SCC, SCR or AIR. None of them reported, but it's available in the judge's library, my lord.
I must
My
thank
lord,
the
we
registry.
kindly call for that judgment.
I must thank the registry able to recover this order. There is the reference order. Yesterday night, late night, we were able to get it back. I must thank the registry a lot.
Most grateful. Thank you very much. Thank you for the cooperation at the